Hello there.
Hello.
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 Hello, guys. Oi.
Hello.
All rise and like, subscribe, and bang the gavel, baby.
Good afternoon. It is time. All rise. Order into court and all that. It is time for We Got a Case. Sorry, we're a minute or two late. That's my fault.
I thought it was going to be my fault. I got up to go take a piss, and all the bathrooms were full. And I was like, "Oh man, I've got to go outside."
Oh, well, at least you didn't use the sink.
No,
You
ooh,
know.
gross. People eat out of that.
It happens. Welcome. Hope everybody's Friday is going good so far. Looking forward to it because, Fridays are harassment courts. So fingers crossed. I mean, they're always bangers, right?
Oh,
Every time.
There's always, he kind of lets them go, and that really makes for a good case.
It's very, very true. If you're new here, we jump around to different live Zoom court that's happening. I've got a brand new one pulled up, which is a probation thing, but I think we should start here. Just a couple of things. We're not judges, have nothing to do with any of that. We're not claiming to be, just so you know.
We're not judges. I think we're great judges of character creation.
Here comes the judge. Here comes the judge.
Of characters, sure, or character. And the other thing, we'll try to be as quiet as possible, not talk over anything important. I think that's it. Let's do it.
Let's step on in. By the way, before we got in here, the prosecuting attorney was talking to the judge, saying, "Yeah, I filed this, I filed that," and the judge says, "There's nothing in here, right? There's nothing here for you to. There's nothing in Odyssey. I guess they use Odyssey over there. So
that's what I think that's their thing that shows their criminal history and all that.
Yeah. So I think they've had to back out for a minute to see if the prosecutor can get her shit together.
Oh, well, that's fun.
Yeah.
Yeah, it doesn't look like they're doing it. Let's start over here real quick. Just keep an eye on that. This one just walked up to the podium.
With the trial date being set.
That chair has something to say. Go ahead, chair.
Okay.
Yes.
The guy on the top looks like he's in a comic book cell. Like you can see him coming to the podium. Dun, dun, dun.
So it's loaded into the pretrial conference order is loaded into Old Court. Can you see that now?
Angie, look at you just on time on a Friday.
So we can set a motions hearing if that's necessary. And has all discovery been completed?
The judge is a million miles
As
away.
far as I'm aware, Your Honor.
And she's up there in the ceiling. You notice that?
I was wondering why she was sitting in the ceiling. She's dropping an upper decker.
All right, lots going on here. Let's
nothing's happened here yet either. It's called Come On, Let's Wait Friday. If you're waiting, just wait a little bit longer. Something will happen.
We had 2 days of just weirdness. You know what I mean? Let's try not to do that again today.
Well, I mean, we can try all we want. It doesn't mean anything's gonna happen.
Right. Fingers crossed for
Mavis. Good to see you. I can jump to something else if you want me to.
I'll pull something up here.
Okay.
Find something. Got to be going on, right?
Yeah, we've got some stuff going on several locations today. Just some people are having a bad Friday already.
Apparently not for me yet. This is fun. Fun start Let's hope that the rest of the day does not go this way. By the way, quick scheduling update. Members only tonight actually is going to be pretty fun. We're not taking a deep dive, but more of a
Well, you said deep dive, my friend.
yeah, but the first round of this, because I think that we actually can do this like twice actually. I want to do kind of an introduction to the villages in Florida. And if you don't know anything about the lifestyle that they live there,
Oh, something's
will-
attacking attorney Eric. He just swatted at something.
well, he'll be all
Whoa.
right. I mean, he's got
Sorry.
a mask that covers up
I thought it was a
90% of his face. Anyways, gonna be a really fun members only tonight. That's what I was gonna say. It's 6 o'clock. Just saying.
The Villages of the Damned. Well, we come over here and everybody gets all quiet, like where the bad guys have walked in.
Mikey, everything that I pull up over here, I don't know what happened to like the algorithm or whatever.
Mhm.
There's one. I can't.
Well, I don't even look at that. I just go to the side and just go court by court by court to see what they're doing.
Yeah, you're correct in that Judge Wilcox didn't put it on. It is a standard requirement of supervised probation. So yes, I'm going to order that one, you do one today, and two, you do one whenever probation directs.
Right.
So if you report down to them. Thank you,
Beat
Your Honor. Yep,
cheeks.
thank you, Mr. Kresge. And so we'll see you back in court, but make sure you get that release of information.
We'll see you soon, Kresge. We know you're completely.
Thank you, Your Honor. Yep. And let me know if there's any attitude issue.
Okay, thank you, Your Honor. Have a good day.
Yep.
Jeanette has a really nice puffy shirt on. I like that. Like something a girl in 1994 would
Mr.
have wore
Schuler?
to school.
The next matter is going to be Lita Williams.
All right, thank you.
Miss Williams, what did you do?
Ms. Williams.
If you hear my wife at all
Activate
talk
audio.
up and
please.
down the entire house is as loud as can be, let me know, please, because
Oh,
I've already said
absolutely.
it twice. Please.
Good morning.
Morning.
So when it's all here.
So we're here for a sanction hearing for a positive UA. I do know that she does have a marijuana card. She was informed to go fill out the remaining documentation from probation in order to get that recognized.
Oh no, she peed
Thank
positive.
you.
I don't have any information if she has completed that.
And Ms. Williams, have you gone to see Ms. Dickinson and worked on that?
I saw one of the probation clerks.
That's a no.
I'm not sure if it was Miss Dickinson. I don't remember her name, but she gave me a form to fill out, or for the doctor to fill out, and I faxed it to him.
When did you
Easy
fax
does
it to them?
It was about 3 days ago.
Okay. And is it fully filled out? Did you get your doctor to make a statement about whether use of marijuana is your only medical option?
Yes,
Yeah, you did? You went to your doctor and they signed it for you?
yes.
So you can go to the doctor and have to fill out a card that says that marijuana is your only
Probation, I
form
don't
of
see anything
treatment.
entered in the probation file. So you said you faxed it to the probation department 3 days ago. There's nothing in the file right now. Was it yesterday maybe, or this morning?
Stephanie,
I sent it to the clinic 3 days ago, but I haven't checked back to see if they.
Oh, okay. So you sent it to the clinic, not to probation.
Yeah, but I gave them the information. The contact
enjoy flush.
information for the office.
Okay. All right, yeah, we don't have any indication that.
I don't
we
think the
have
judge
paperwork,
believes her
so
creed.
We need to have the paperwork, and you can't use, even with the card, you can't use any marijuana at all until you get the okay from probation, meaning they review
saw
the
you
form
on,
and they
but
say,
I
yes,
can
now
only
it's
take
okay. It's not just
so much.
having
We have
somebody sign off on
every
it.
day,
and,
you know what I
okay,
mean?
that
It's
does
Judge
away with it.
Terry's
No,
there. It's
you
not
have to
even
get
Judge Kim.
probation's approval. meaning they've reviewed the form and it has all the necessary information. So if you're using now, you're in violation. You can't use, even though you may have a medical card, until you have the authority of the court to use pursuant to that card. Understand?
Yes.
Okay, and so at the moment, we don't have the card, or I mean, we have the card, we don't have the compliance with the policy statement. So if you want to hand carry one down to make this happen faster and get probation's approval to continue your medical use,
The old
then
hand
that's
job
up
where
to
you
you.
take it
But
all
right
down
now,
there
we don't
yourself.
have anything. So right now, any use is in violation of the requirements of the sentence.
Okay, I'll come hand it over in person.
Thank you, Dawn.
Yeah, if I were in your
Happy.
position, I would hand carry it all the way around to make sure everybody has one. Okay, the state's filed. a
I
motion
suppose you
vote
would be
based
putting
on
them
that
up on
positive UA.
lampposts
We
up
don't
and down
have
the town.
information yet that you have taken the steps necessary to rectify the non-compliance with the policy. So we'll,
Sweet tea coming in strong with a
I guess
challenge.
let's do this. Ms. Schuler, is there any disagreement that there was
Lady
a
Fang, I
positive
don't.
UA?
I'm almost certain.
No,
they have
there's
not,
no disagreement. I also note for the court that she's in full compliance
reconvened.
and absent the positive UA.
Okay, so we'll note the positive UA factually.
I asked nicely.
The issue will be whether it's solely because of misunderstanding on the need for the compliance with the medical marijuana policy, and that will be enhanced, Ms. Williams, by you actually following through on that policy and getting the letter to the probation department. So we'll set a hearing, and if you've done all that, then
Getting it started, T. Thank you for the 5 bones.
It seems like they're really strict
Okay.
on
you understand what you need to do.
even though you have a medical
yes, Your Honor.
a
Okay,
medical
and let me
marijuana.
let me
the
confirm a
pot
mailing
card.
address here.
I was
I'm
nice to me,
showing.
but the
Are
last-
you at?
The best part, if
It's
you ever
either
rewind
General
it, watch
Delivery
Creed
Packwood or it's
through the
111
door,
Smith
like-
Road in Packwood.
I don't like
Yeah,
having
general delivery.
door quotes at all. It's
Okay, and how about a cell phone number?
not walk back and forth the
360
entire house talking at the top of her lungs.
981-8448.
Okay, so you'll receive notice from us telling you when to appear before the court, and
Hello, Angela.
Thank you, Angela.
primary
Thank you.
issue will be, are you in compliance with the court's medical marijuana
Usually
policy?
just piss people off.
Okay,
That's Creed.
all right, I'll assume there aren't any questions. Thank you, Ms. Williams.
You on drugs?
He wasn't too happy with
And I
her.
don't believe there are any other matters. I don't think there are any people in the courtroom.
Well, Mr. Krisky just came back in. Mr. Krisky?
Carrie, thank you for the stars on the Facebook.
Somehow
And
wait for that.
Lambo Rad, look at you.
Okay, yeah, talk to Ms. Fisher about that.
Thank you. Mr. Krisky's
Yeah,
back.
I don't have the authority to waive
Thank God.
a fee because we don't do the UAs. So there's nobody I can order to give you a free
So, Your
UA.
Honor, if I can't afford this, what do I do?
So just go down, talk to Ms. Fisher and figure it out. That's between the two of you.
Imagine if marijuana was just
I don't
wiped
wanna
off
get in
in these
trouble
court
for not
systems,
going
same
to
in
the
jail,
not take it.
all of it, you know?
Go down and talk to Ms. Fisher and
True.
work it out. We'll text her and let her know that you came up here and that I sent you back down there.
Okay, thank you, sir.
Yep,
Have a great day.
thanks.
Doesn't
Take
the
a look at
judge
that.
look like really an old
Lesbian?
Steve-O?
Oh. Yeah, I can see that.
He does look like Steve-O, like an old Steve-O. The $1 million teeth and everything. What's the judge laughing about? Oh,
You
Judge.
know, he just came up saying the only issue was his finances.
Oh, I don't know. Selfishness, being rude. You know, any of the few things. And by the way, while I sat out there while she went on and on, I had the TV
Brandon
down
O'Neill.
this much for my 20 minutes worth of viewing I could have today. So I was nice.
Appeared. Allegations of failure to report to probation, failure to comply with both domestic violence and mental health treatment. We've received no further information
Puts it on like panties, in the morning. It's not going to take them off until it's time.
Mr. O'Neill called about an
Right
hour
about
ago, but
His breath is
hasn't
offensive.
logged in.
See how the judge is wearing his glasses like up here? They're not even behind his ears.
I actually found a new courtroom that we're not even subscribed to. Just jump
He
over,
has
just
an
see what's
active
going
warrant.
on.
Go for it.
So
Oh, wow. H. Brown, beautiful horror.
33, 24, 45, each
Oh,
one.
45 E1.
Yes. It says,
Thank you.
You don't need to read it.
Everybody's stepping up to the challenge.
in the Massey case, that's Massey versus Allstate Insurance, dealt directly with that, Your Honor, and held that it had to be strictly complied with. That statute had to be strictly complied with
Like
when
myself
they
in
were
this room.
eliminating UMBI coverage from an umbrella policy. So moving forward, because that coverage existed by operation of law, it was never removed from the policy because
And Brown's got an attitude. I could just tell.
notice of reduction in coverage that was provided strict by the statute and has to be strictly complied with. Then Mr. Turner has, as a matter of law,
I've got court
UMBI
today. Let me put
is
my cheetah jacket on.
policy of $1 million.
$1 million?
Huh?
$1 million?
Well, damn. Thank you, Nathan. I look forward to seeing it. Still waiting.
$1 million? Oh, wow. $1 million.
Is this like a life insurance policy thing or
I believe defendant State Farm
salted water? Watch.
they have admitted that there was no return receipt or personal delivery of the notice.
It's the
Aquafina or Dasani? You like that salt with your water, honey?
But to be dispatched by at least first class mail to the last address of record of the
Them too.
insured and of the lien holder where applicable, and receiving the receipt provided by the U.S. Postal Service or such other evidence that is prescribed or accepted. By the U.S. Postal Service. I mean,
Did check get lost in the mail? What are we talking
I
about?
guess you could pay for a receipt confirmation.
That's correct, Your Honor. You can send it by certified mail. You can send it return receipt. You could send it to be signed for. There's several ways of doing that, but they didn't do.
But of course, regular
Thank you, Don.
mail doesn't result in any such
Correct.
return.
Yes,
receipt
because
or
it's not purified with salt.
letter was
Spring
received.
water.
That's correct, Your Honor. So you have to take that step beyond just throwing it in the mail. You have to either personally deliver it, or you have to get return receipt.
That's right, Dick.
If it's not return receipt,
Or
you
Doge.
could have had him personally sign for it. Could have sent it overnight delivery.
We're going to break down every way you can send something in the mail, by the way,
ways
here.
the post office accepts, and none of those were done.
You can take it to mailboxes,
Right.
etc.
Yes, Your Honor. So this argument will be both in connection with my argument for summary judgment against the plaintiff claim for summary judgment.
Pretty sure that's not
And
Curtis's
to the
house.
extent that I have to articulate some type of question of fact, if there is a question of fact, I'll address those issues as well.
Well,
I'm gonna go back.
that's fine. I mean, it seems like a fairly straightforward argument on the one side. So what's the argument on the other side?
Yes, Your Honor. I'm going to go back and put this a little bit of context and a little bit of history. And that is,
I'm gonna get ready for a history lesson from Curtis.
Mr. Turner had
What a weird
three,
choice
what I'm
of
gonna
fake
call
backgrounds.
underlying regular automobile insurance policies. One of those
Flathead
policies
B.
covered a
Hosnell.
Chevy
Look flat.
Colorado that he was driving at the time of the accident. On each of his underlying automobile policies, he carried liability limits in the amount of $250,500.
But that's not salty
In other
water.
words, $250,000 per person, $500,000 per occurrence.
Yeah, I think that's what they're fighting about.
Underlying automobile policies, regular automobile policies, he executed what I am going to call selection rejection forms for each of those.
Selection rejection.
And for each of those individual automobile
Something
policies,
junction.
he chose to have uninsured
What's your
motorist
function?
not equal to his liability coverage, but
Resting
only up to the
bitch
amount
face,
of
they call it.
25,000 / 50,000 per person per occurrence.
Imagine him with
Accordingly, under
what's her
the
name with Judge
stacking
Curly
rules
hair.
for each of his
Mhm.
3 automobile insurance policies, he had a total of $75,000 in what I will call available UM coverage. He purchased these original policies from his original agent, Mr. Ken Anderson, who had been his agent since before he had procured his PLUP. They have an ongoing 30-plus year relationship.
Okay, but
filed
Mr.
the-
Anderson, we're only concerned about the club,
Sounds
right?
like a plan. Let's do it.
Not necessarily, Your Honor.
Loud membership has its
Okay,
privileges.
why?
Because as a second condition, Mr. Turner did not have the requisite amount of underlying coverage to qualify for coverage under the umbrella.
Curtis lives very
even if
close
he
to
had.
Mikey.
Prior to the Abrahams decision,
home
there were
base.
no carriers, PLUP. There were no auto insurers who were obtaining selection rejection forms for PLUP policies, which may or may not have contained uninsured motorist coverage.
He's a
Along came
terrible
the Abraham
lawyer.
decision, and they read that in. The legislature then in 2008, with an effective date of January 1, 2009, amended the statute. And when they amended the statute, they did what I call the Abraham's fix. They went back to the way insurers were doing it prior.
When to
And
say
they
Bob?
specifically indicated in the statute 33711A3 coverage policy
With 10 bones,
includes
upping the challenge.
umbrella policies provided
TK.
for in the policy, which neither of these policies did.
Are we bored with
After
insurance talk at this
January
point?
1,
I'm really bored with him for sure.
Yeah, he's
guilty
annoying.
to the current charges. I'm sure that was the issue. And if you're telling Mr. Nagel that he is willing to change his
Whoa.
plea and accept the plea agreement regardless of the court's decision, then the court doesn't need to make a decision in advance on the offender score. It's something that has to be done at the time of sentencing. So with that being said, I'm willing to hear this matter Monday, 3:30 for change of plea, as long as Mr. Lewis accepts that, the fact that the court may end up counting these Australian convictions against him in his offender score. So, Mr. Lewis, I'm going to inquire of you directly. All right, can you hear me okay?
Could be part of your offender score, right?
So,
I mean,
Mr. Lewis,
it's
your
another
attorney
country.
indicated that you have reached a plea agreement with the state
know
and
how
you
I
intend to
feel
plead
about that.
guilty pursuant to that plea agreement, regardless of the court's decision on your offender score,
We did say
meaning
Australia,
whether or
right?
not these Australian convictions count against you. Is that accurate?
I wanted to clear the record completely before I reached a plea agreement. That way I'm getting sentenced appropriately.
Good day, mate.
Okay, so let me just follow up with that. So are you saying that you are not, okay, so just to be clear, you do not intend to plead guilty until, or you do not want to plead guilty and accept the plea agreement unless and until the court makes a decision regarding these Australian convictions?
Yes, sir.
Wow.
And Your Honor, I think that means me and Mr. Nagel needs to talk more about that offer as well then.
All right. So this is how I see it. I'm just going to make it very clear. There's a trial date. There's either a plea or there isn't, right? So if there's a plea agreement reached, fine. If there's not, we go to trial. If the plea agreement is reached, it's reached regardless, right? The plea is based on the plea offer on these charges. If the offender score issue is unresolved, then we'll have to resolve it at sentencing. Mr. Lewis can either accept that or not. I mean, that again, this is a sentencing issue. It's not an issue about guilt or innocence or trial or not, or plea. That's not in the court's estimation. Those are separate issues. So if there isn't a plea deal, then there's a trial. That's the bottom line. If you want to reach a plea agreement, that's fine. And then we'll have a hearing either before sentencing or at sentencing on the comparability analysis and the decision on those other crimes. All right. So Ms. Zorn, I hope that we can get that information promptly, maybe follow up with them and see what the status is. And then let's review this on, let's set this for Monday at 3:30, just in case one of you counsel discuss the matter and see where we're at. And then we'll make a more informed decision on Monday as to how we're going to proceed.
Yes, Your Honor.
All right. Thank you very much. Monday at 3:30, present an order.
Thank you. And Mr. Nagel, if you'll stop by the office.
I think that hit the
Right, thank you.
judge
Court's in
kind of
recess.
wrong. He wasn't expecting him to say no, he wasn't going to take the plea deal.
Mm.
But you have to think too, if you have charges in Australia, should those count towards here? I mean,
Well, I mean,
obviously they
your
let you in the
offender score,
country.
though. It's your
Yeah.
offender score. I mean,
Right.
it is. I think so. Who the hell am I to say? But I mean, I'm just saying, if I committed, if I had any charges of anything in another country, I wouldn't expect to go to another country and just be free and clear. Your
they
offender
could've been-
score, if
yeah.
I'm not mistaken, they use, as to, I mean, that's your.
Right, depending on would help decide.
I don't see why
how
that's
many
an issue.
years.
I don't know.
Kennedy, the court's found probable cause to hold you to answer to a charge.
Cowlitz County, a new one we just
Violence,
subbed.
gross misdemeanor with a maximum potential sentence of 364 days in jail, a $5,000 fine, and potential $5,250 in assessments. Take a moment and go over your rights at arraignment. You have the right to be represented by an attorney of your own choosing.
Yeah, the way I understand that is that it's just it's your offender score. So they're using that when they're giving you bond or sentencing or any of that info, right? I mean, that's what I would imagine.
That's the
So,
layman's terms of what
yeah,
we've
it's
understood.
it's your Wikipedia. So I mean, I don't see why it wouldn't. I mean, I don't expect to go and rack up a bunch of charges in another country and then just move to another country and be, you know what I mean?
Yeah.
Tell witnesses to appear at no expense to you. You have a right to silence.
When you're done listening to him, if you want to jump out to harassment court, it's up.
You have a right to disqualify up to one judge if you do so in a timely manner.
Yeah, again, that's
If
only
you
your
are convicted of
offender
trial,
score. So
you
it's
will
not
have
like
the
they're
right to
using
appeal,
them
provided the notice of appeal is filed in a timely manner. If you
in
plead
anything
guilty,
other
you
than
have all of these rights.
to get an
Also,
idea of
you are
your
not a citizen,
past.
you have
I
the right to
guess.
consult with an immigration attorney, and the reason is that criminal conviction for a non-citizen could result in deportation, exclusion from admission, or denial of naturalization pursuant to
That
the
could be
laws of
too
the
for some
States.
higher up
That being
things.
said, would you like me to appoint an attorney to represent you in this case?
Yeah.
Okay, I'm going to
Duh.
appoint the Grimm Law Group to represent you. I need to
Judge,
check with my
of
clerk.
course.
I know we've got one other case that's pending with the Grimm Law Group representing you.
I don't know if,
But I think we've got our attorney out. Could you check?
The name Grimm really works
Are you
well
showing
with,
one file,
you
Ms.
know,
Grimm?
Attorney Grimm.
Jabs right now.
That's okay. We're looking.
if she just move over to the left a little.
Somebody, she lost her nose. Somebody throw something so she'll
Oh,
turn her head. It's kind of
Lord.
creeping me out.
Oh,
Have you filed your attorney application in the other case? Okay, very good.
oh, hello.
I'm going to appoint the Grimm Law Group
Hey.
to represent you. I don't need a new attorney application. We're going to have her knock. I want to hear from the prosecutor now on requested conditions of release and bail. Go ahead, Ms. Grimm.
Guys are
Your
amazing.
Honor, we would be requesting a bail in the amount of $5,000. There is an open case against Mr. Kennedy with the same complaining party,
Oh.
his wife. We would also additionally be requesting a no contact order in this case, preventing him from having contact with the alleged victim, as well as going back to their shared residence. If he does make bail, we would just
Is
request
that one of the big money Kennedys?
post still with that no contact order.
Thank you. Ms. Grimm?
All right.
Certainly.
Is she going to talk good
Your
about
Honor, I
him?
understand he's got a current pending case. I mean, obviously, we have to presume he's
Innocent.
not guilty of either one, innocent of those at this point, or not guilty of those at this point.
Hi, Jeanette.
He has no warrant history, has very minimal criminal history. I think the pending charges are the only things that he has that we can consider on his history. We'd ask for
For
PR.
sure.
Okay, I'm gonna set bail at $2,500. I'm gonna set the following conditions of release. Number one, have to report any change of address to the court clerk and your attorney.
See with your big bingo wins.
Release, contact your attorney and give them your current contact information.
Carol said, let's
Other
get
conditions
physical.
are do not use
Physical.
any controlled substances. We're gonna have a readiness hearing. You must be here. I'm sorry. Pre-trial, April 12th at 1 p.m.
Oh, yeah, he does.
Must be here at that time. Readiness hearing, April
Around a panel and
1 p.m. via Zoom. Jury trial, May 13th at 9 a.m. That one is at the courthouse. Other conditions of release. Report to offender services immediately upon your release from the jail and report to them 3 times a week thereafter. Submit to any urinalysis.
this is one of the cleanest looking jails we've been in a while.
Yeah.
Use controlled substances
And
unless controlled
the other thing, are we
prescribed by a physician.
where's Niner?
Only as prescribed.
Do they not have a Niner?
Offender services.
Nah.
If
This one's
they
just
have
straight up,
reasons
nobody talking good, you know?
reasonable
Look,
ground,
her
you violate
grandfather clock
We're
works.
entering a pretrial domestic violence no contact order. You may have no contact, direct or indirect, Leslie, Gail, Fredericks. You may not own, possess, or control a firearm. You may not
That'll be.
access, own, or possess a dangerous
Danny
weapon.
B. Hair.
Concealed pistol license. You must immediately surrender any firearms
Enjoy your
or
lurk,
concealed
our
weapons
guy.
license, concealed pistol license to the Kelso Police Departments. I'm going to allow a civil standby for 1018 South 6th in Kelso. That means that if you get out, you need
Mayor?
something from the house, you can go to the Kelso Police Department. They'll go to that house with you so you can get some things.
Don't go there.
You,
For God's sakes, don't go there.
Your Honor, may I interject?
Sure.
When did you set trial?
I set trial
May
for May 13th.
So
Certainly
a month,
looks-
Mm.
we have a month from arraignment to trial, a little over a month?
No, you've got 6 weeks. Right
No.
now, he's in custody and we're on a 60-day speedy trial.
Hello, Bob.
That
Donna.
would put us through June 1st, Your Honor, not May.
May 13th. I'm not going to set it right at the end.
It's April
If we come
1st.
close,
So
and you wanna-
we've got a month to get an assault case, little over a month to get an assault case prepared for trial when he's got another one pending.
No.
That seems awfully short.
6 weeks.
It is short, but he's also on a 60-day speedy, he's on a 60-day right to trial. If you want to file a motion to continue and file a speedy trial waiver, if he remains in custody, then I'm more than happy to hear the motion. And if he does get out, I'm more
Does
than
say
happy to hear the
affordable
motion
right
to
there.
continue that date. But,
All right, so readiness is April what?
25th.
25th.
Mayri was
Kennedy.
looking forward to going out of town, I think.
Yeah, I think she had a hot one coming up.
9 a.m.
She's visiting her house in the village
Mr.
in
Kennedy, I have entered
Florida.
conclusions of law, granting an order to surrender weapons. I have entered an order to surrender weapons. You must appear before this court on April 7th. That's next Thursday at 10 a.m. via Zoom. If you're out of custody, to prove that you've filed either.
Can she not go back and just get him to out a couple more weeks? We're finding this, doing that. We
Well,
see
he's
that all the time.
yeah. Well, he just told her that. He said if you want to waive the right to a speedy trial, you can do so, but he's got to fill out the paperwork to do so.
Let me see here. Second. I think that's it. Anything else, Ms. Grimm?
No, Your Honor.
Nope, I just
Anything
hate you.
else?
You're on.
Don't ever send me flowers
Nope.
again.
My weekend
Okay,
is
thank you very much. I'll take care of
now. Thanks, Judge Hayes. By the way, what happened to the wall back there where that guy
Lacey
sitting?
Malone, Your Honor.
There used to be a window, and zombies busted it out, and he had to
21
put that
seconds,
plywood up
Mr.
over
Warren,
it.
so I can get organized here.
Ooh, no
Where
bra.
is Cowlitz at, by the way? 360.
No bra. There you go. Cover them up.
Okay.
This is a family
Lacey
show.
Kelly Malone, is that correct? Ms. Malone, I have
Vancouver,
here
Washington.
a statement of defendant upon plea of guilty to a charge of illegal use of a trip permit and to driving while suspended in the third degree in the cause number that ends in 899. I also
Too
have here a
fast.
statement of defendant upon plea of guilty to a charge of making a false or a misleading statement and to obstructing a law enforcement officer in the cause number that ends in 0012. Have you had a chance to review these documents with your attorney?
She's a liar.
Okay. Do you believe you understand them?
Yes,
And did you either sign them or allow somebody to sign?
I
for you?
allowed her to sign them.
Okay, thank you very much. You understand?
Got some
that
good
the elements
videos
of the
tonight,
use
Jay.
of
It's
the
gonna be
trip
fun.
permit Are that you operated a motor vehicle within the city
I
of
can't imagine.
Woodland, and you used a trip permit for more than 3 days, or you used it for a vehicle that it was not issued for, or that you had taken out more than 2 trip permits, or that you had failed to identify the vehicle on the trip permit. There's a lot of ways to commit this crime. You understand that those are the elements of this crime.
Yes,
One
Okay.
crime,
You understand
many
that the
different
elements of
ways.
Driving while suspended in the 3rd degree are that you, within the
Pick
city
your
of Woodland,
choice.
operated a motor vehicle while your ability to do so was appreciably, while your license was suspended in
Appreciably?
3rd degree.
Edward?
You understand now?
yes,
You understand that the elements of making a false or misleading statement to a public servant are that you, within the city of Woodland, made a false or a misleading statement to a public servant under circumstances in which the law required you to speak truthfully if you spoke at all. Do you understand that?
yes,
Did you notice
understand
she
that
has
the
a spare
elements of
tire, much like
obstructing a
Bishop
law
has?
enforcement officer are that you, within the city of Woodland, obstructed the law enforcement officer in the performance of his or her official duties. Do you understand? Those are the elements.
yes,
You understand that by entering these guilty pleas, you're giving up your right to a speedy public trial in front of an impartial jury. You're giving up the right to remain silent. You're giving up the right to hear and question the prosecutor's witnesses. You're giving up your right to testify on your own behalf. You're giving up your right to call your own witnesses and compel witnesses to appear at no expense to you. You're giving up your right to be presumed innocent and force the prosecutor to prove each and every element of each and every crime beyond a reasonable doubt. And you're giving up your right to appeal from a determination of guilt. You understand that these are your trial rights and you're giving them up by pleading guilty.
yes.
These biscuits.
The failure or the false statement to a public servant and the obstructing a law enforcement officer are each gross misdemeanors with maximum potential sentences of 364 days in jail and a $5,000 fine and $5,250 in assessments. That's on each. And on the driving while suspended third, the maximum potential sentence is 90 days in jail and a $1,000 fine plus another $1,050 in assessments. You understand those to be the maximum possible.
Yes,
Now, the prosecutor's going to make a recommendation of 10 days in jail on each, with the remainder of the jail time suspended for 24 months. Those 10 days in jail converted to 10 days of out of custody work crew. All those sentences, the 4 to run concurrent for a total of 10 days converted to out of custody.
I like this
work
judge, by the way.
crew, and that they're going to move
Yeah,
to
yeah.
dismiss the trespass 2 charge in the cause number that ends in 051, the failure to transfer title in the cause number that ends in 899, and the assault 4 in the cause number that ends in 733. Do you understand? That's the recommendation. Okay. Now, I have to dismiss those other charges if I accept your guilty pleas, but I don't have to follow the recommendation on the sentences, and I could give you a sentence up to the maximum on each. Do you understand that?
yes,
Okay.
Do it, Judge. Make an example.
I think she's being on her best
Understand
behavior at the
that,
moment.
Oh yeah, she seems like
See,
you are
she's
not a
really
citizen of the United
Yeah.
States.
tune up the ban if she wanted to.
Punishable as a crime
Yeah.
under state law is grounds for deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Is that your understanding?
yes,
Okay. Then to the charge of trip permit violation. How do you
Yes,
plead guilty or not
street
guilty?
game. Street game. We see this a lot,
And to
a
the
lot
charge
with
of
the
driving while suspended in the third
first
degree. How do you
appearance
plead
stuff,
guilty
though,
or not
where they're mixed.
guilty,
To the charge of false statement to a public servant. How do you plead guilty or not guilty?
guilty,
And to the charge of obstructing a law enforcement officer. How do you plead guilty or not guilty?
guilty,
Are you making each plea freely and voluntarily?
yes,
Has anybody threatened you to get you to plead guilty?
What's a trip permit,
Has
by the
anybody
way?
made any promises to get you to plead guilty other than
Maybe somebody that was on I don't know. I was thinking like on probation or something, and you'd
We
have
have
to
to get
get.
permission.
It's the only thing I could think of.
I have a statement that says, on April 24th, 2020, in Woodland, Washington, I operated a motor vehicle on a public highway with an expired trip permit. On that same date, in Woodland, Washington. I operated a motor vehicle while my privilege to do so was suspended, but immediately reinstatable without a period of further suspension.
It's a temporary
Another
license,
statement that says,
also known as a trip permit.
on December 11th, 2019, in Woodland, Washington, I willfully hindered and delayed a law enforcement officer in the discharge of his or her official duties. Are each one of those statements true?
Yes.
Okay. I also have a statement that says, and this is on the making a false statement charge, I am pleading guilty because I believe the city has sufficient evidence if presented.
Cost you
at trial,
$25
and the
for it,
judge
by
or
the way.
jury believe that evidence, that I could be found guilty beyond a reasonable doubt of the crime of false statement. I am pleading guilty in order to take advantage of the city's offer. Is
Look at
that all?
everybody with their head hung
Yes.
low.
Okay, fine. And I've had a
Not
chance to
yes,
review
Kirdoff, but it's going to happen
police
one of these
reports
days.
on the charge
It's
of
gonna
making a false or misleading statement, and I do believe that there are sufficient facts to support. I will find that the defendant has knowingly, voluntarily, and intelligently entered a guilty plea on each one of these charges. And I will find her guilty.
That's pretty nice,
on
unless they get it and they
each
bring
one
it back
of the
into and
charges
they
of
get in
use
trouble
of
for
illegal
it.
Trip permit, of illegal use of a trip permit, of driving while suspended in the third degree, of making a false or misleading statement, and of obstructing a law enforcement officer. I have
With an E.
noted on the judgment and sentence in the cause number that ends in 899 that the third count of failure to transfer title has been dismissed. I've entered a separate order of dismissal in the cause number that ends in 051. That's the trespass 2. And I've entered a separate order of dismissal on the cause number that ends in 733. That's the assault for domestic violence. On sentencing, Ms. Keller.
Wow. Where'd that come
Your Honor,
from?
we would just request that you follow the agreement.
Trespassing and domestic
Yes,
violence?
Your Honor, Ms. Malone has a back injury that's going to prohibit her from
Bet she does.
doing any kind of work crew or anything. She's in custody
Oh,
right now.
stop
according
it.
to the jail. They've confirmed as of today she will have 4 days for credit on these cases. We'd ask that the court, if the court's going to convert the balance to an alternative sanction, not including jail, we would ask that it be done on a community service basis. We don't believe that she physically would be released to be able to do work.
Hallelujah, thank you.
Ms. Malone, is there anything you'd like to say before I sentence you?
I'm ready to go home, be with my dog.
Okay. How long have you been in custody?
DAWG or DOG?
Monday?
Okay. And you're only sitting on these charges? Is she only sitting these cases, Ms. Grimm?
That's my understanding. According to the jail, she has 4 days to get credit for on these. Let me look at the jail real quick.
Hoyts. It hoits.
My back hoits. Would you like to say anything? I can't wait to get home and eat a Whopper
Can I go
sandwich.
upstairs and come in and drink?
Miss 74?
Yeah, she's
Miss
only in there
Legend?
on these.
Okay. Give me a second.
I was kind of thinking the same thing, guys. Not gonna lie.
Okay.
She has allergies, Your Honor.
On. Oh, sorry, I gotta fill something else out.
She doesn't feel well. She doesn't play well with others. Your
And they
Honor.
show booked 3/28 at 11:50 hours.
Yeah, you're right. That's a big clock for that little office.
Amanda, the way that she's, I'm assuming looking at the computer right in front of her, she looks very woke, though. You know,
She looks
her eyes can
lonely.
pop.
She just needs the love of a good man or woman.
This is what I'm going to do. On the charge of trip permit violation, I'm going to impose 4 days in jail with 360 suspended, $5,000 fine with all of it suspended upon my determination. On the driving while suspended in the third degree, I'm going to impose a 90-day sentence with all of it suspended, $1,000 fine with all of it suspended. And in the false statement to a public servant, I'm going to impose a sentence of 4 days in jail with 360 suspended, $5,000 fine with all of it suspended. on the obstructing a law enforcement officer. I'm going to impose a sentence.
He's cutting her a deal, man.
Jail with 360 suspended.
He is.
$5,000 fine with all of it suspended.
Hang on. Hallelujah.
Each
Income.
count on each of the two cause numbers runs concurrent with the other count.
Thank you, Sergeant Buzzkill.
Thought these things were broke for a second.
Charges.
I wanted to hear the charges.
She had a lot of them.
Should put her out today. Now, suspended time. I've got a lot of suspended time in both jail and fines hanging over your head here for the next 24 months on the following conditions. Have no criminal law violations on any act committed after imposition.
Not cheap.
Today,
Affordable.
and do not drive without a valid license and insurance. I'm going to send over this judgment and sentence to you. We've gone over a lot today, but the bottom line here is that I am pretty much cutting you a break and letting you go today. If you come back in front of me, I've got a lot of time here and I'll unsuspend it, okay?
Okay.
Any questions?
Take off your mask and let the judge see your happy smile.
Yeah, right. Rag a monkey. Court this. Wow, what was that? A court fart? Did you hear that?
I think that's
The guy accused the judge of being a blood harvester. Wow, they cut that one quick.
That was a quick out.
And Colleen came
Holy
out.
cow. Oh, that's
I ignored him.
went
Melody
harassment
stood
court.
in front of my car looking in, and she said something, but because my car was shut, I could not hear.
that's
so I,
almost like some 90 Day
lightly opened the
Fiance stuff.
door
Harvesting
to
money.
my
You know?
car, and I said, "What?" And she said, "Oh no, Isaac." And she looked like she
Harvesting
was
the
about to
American
cry.
dollar.
I said, "No." I closed the
It's an
door back,
ancient teller, right?
and they left. And then it was the incident in January 11th.
Visually, this is a great
where I was coming back
courtroom at the
home
moment.
with my son and my dog. We're coming back from the park. I got
park?
them both out. I was
Ragu
talking to
Monkey
my
was there
son, my dog
arguing
was
with
barking.
cops.
We walked
Yeah.
halfway up the stairs when I heard Melody's door unlock.
She
She
I'm
came
gonna
out,
be
started talking to my
Okay.
son, told him she just wanted to say hi and that she loves him, and
Well, that's creepy.
and all the rest. It's in my declaration. When we got up, I opened the door. I got him and my dog inside. I turned around. I told her, "Please, I have asked you to stay away from us. You cannot keep doing this." And then she started yelling at me that she was going to call CPS because I was not going to keep her away from my son. I told her, "Please, I have asked you to stay away from us." And after that, she threw the ball at me. I just finished picking up the balls and went back inside. I immediately called my
Threw a bowl at you?
advocate. She said, "Call the police, make a report, call your management." And I did that. And when I talked to the officer, he said, "Yeah, that is not right. You have asked them to stay away from you, and she doesn't want to listen." And it's really disturbing that she's doing this to a 3-year-old.
When you say she, is that Melody or
Yeah,
Colleen or both?
that was that was Melody. Colleen was not there that day, I believe.
Can you? I feel like maybe the two response are kind of getting, at least maybe in my mind, like mixed up in terms of who's doing what. Can you tell me kind of just generally who you have more concerns about or who's contacting you? And we just kind of start with the January 4th from there.
DK, I won't make you pick up any trash. Don't worry.
Well, actually, in January 2nd, the first communication came from Colleen in an email asking me to basically telling me that I should not feel upset about what they said and what they did. And it was a long email. After that, I replied back.
Maybe.
I think the same day, I can remember right now. Yeah. And I told her, "Well, thank you for sharing your thoughts. Have a happy New Year's." And later on, she replied back and she said, "Gee, I don't
She said,
understand what
"Bitch,
you're
it's
trying to
March
say,
3rd.
or
What are you
wishing
talking
me
about?"
To have a good life and goodbye, or you just don't know how to communicate what you want to say." So on January 4th, after talking with my therapist, I sent her an email saying, I'm just asking you to please stay away from me and refrain from approaching me and my son, both for you and your mom. And I'm also letting you know that I appreciate the time we had our friendship, but I no longer, this is not a friendship I longer want to continue with.
Damn. Gotta go to
And
court
I
over a
also
friendship
put in
ending.
there that we should return each other's belongings. And honestly, I thought it was going to be the end of it, because as an adult, if somebody sent that to me, regardless of any past relationship, I don't understand that, okay, they're setting a boundary. They don't want to be friends with me. I have, even if that's upsetting to me, I have to respect that, especially because we're talking about a 3-year-old. I didn't hear back from them at all. So I thought, oh, good, this is good. They are respecting this boundary. And it wasn't until January 11th, when we were coming back home, that Melody came out. She yelled at me. Like an hour and a half later, after that incident, I started getting emails from Colleen making threats, telling me that I was crazy, telling me that if I kept like reacting to their abuse or setting more boundaries, basically, they were going to be
Kirnoff, no, he
forced
does
to,
stuff all week, just like a
to
normal
reach out to
judge,
my
just on
ex-husband
Fridays harassment.
and
Yeah.
call CPS, just like Melody yelled at me earlier that day during the interaction we had. And late after like 2 or 3 emails from Colleen, I received another email coming from Melody where she put it in there. You will not control me. You will not tell me what to say. I'm going to keep talking to Isaac just like I have always done. So it is in there. They can say that they didn't say it, that Melody didn't yell that at me, but she used the same language in her email as to what she yelled to me earlier that day. And after that,
I can't understand if they
on
had like
January
a loving
13th,
relationship or they're just
I
friends.
received an email in Facebook Messenger coming from Melody with this like
Read into it, I guess.
religious poem talking about
Poem.
letting go of
Poem.
my control, that refers back to what she was telling me, that I was not going to control her. They say that there's no proof of that, even though I have submitted the proof that she did send it that day.
That they told me to piss off.
After that, there was, I believe, no more contact with them until February 11th, when it can be heard in the audio that I was driving, I parked, both my son and I saw Colleen with another neighbor outside. He asked me if he could go talk to her. I said, no, I don't want her near you. We have to stay here. And then he asked if she could come to our home. I said, nope, she cannot come to our home. And we waited there. We waited in the car
Oh, harassment court is
until she
very
left.
petty.
And it
Oh,
took about
yes,
3 minutes.
absolutely.
And when she was gone, we came out of the car. And you can hear that as we were coming out of the car, you can hear Melody in the back saying something. And you can hear that we're walking as we walk closer, you can start to hear better when she's talking to my son. So she was very clear in her communication. I'm going to keep talking to your son. And she did, because she came out explicitly to talk to my son. Even though she knew my request to stay away from him. You can hear her say, hi, how are you?
So friendly.
And she told me, did you got that nice piece I sent you? And I believe she was referring to the Facebook message that she sent to me. And after that, she kept talking to my son. And my son asked if she could come upstairs. I said, no, she cannot come here. And she said,
Apparently
no,
the little kid really likes this woman.
But you need time with your mom. I just wanted
hashtag never forget.
come and tell you, say hi and tell you that I love you. Once again, I have already asked them to stay away from him, but she just cannot help herself.
Can we see the
into
video?
Getting in contact with my son. I don't
Right.
understand why, but it is really concerning for an almost 80-year-old woman to be so desperate in
80.
her attempts to reach out to a 3-year-old.
Yeah, the judge
Question for you. Do you still live?
the judge lets
are
them
you
go
still
on.
neighbors with the Melody and Colleen Marr?
No, I'm not. My concern is that they live 3 minutes away from his school. And based on all the threats that they have made, I have a real concern that they're going to keep trying to reach out to him or do something, or
I
even
didn't
if
see
we
them
run
live
into
today
them
yet, my Michelle.
at the grocery store, that they're going to keep doing this type of behavior.
80-year-old
See,
bully.
and then,
Yeah.
For the respondents, is it Mar or Mayor? How do I say your last name? And you can unmute yourself.
It's Maher.
Maher. Okay. And so for either Melody or Colleen Maher, if you'd like to, you're welcome to respond at this point.
Okay. So, first of all,
And I'm sorry, is this Melody or Colleen?
sorry, this is Colleen.
Okay, thank you. Go ahead.
First of all, almost all of what she said was little bits of truth that she's spun
Everything
to
she
be
said was
something
a
that it isn't.
goddamn lie.
She has taken what I've written and made her own decisions on what I meant by what I said. Or both of us, what we meant by what we said.
Chuck, thank
Okay,
you.
so a second. So, okay,
Appreciate you.
so as it says, her testimony is based on emotion and opinion. She's saying that we said things that we did not say.
Verified Chuck's
She's saying that we
statement.
said things
Correct.
and this is what we meant. And what we meant was not what she's turning it around into.
None of them sound
She's
80,
made
so I'm
multiple false
confused.
statements.
Who's Chris?
She has basically, okay, so in the, okay, a couple things. First of all,
I don't believe her already.
Yeah,
didn't
she
want to
is
talk to us,
doubling
all
back
she
on
would've had to do
herself.
is
It
say
sounds like
that.
she's making stuff up as
You know,
she
she's
goes.
saying this started back in April, but her first thing says it started in June and then started in August, and now she's saying it started in May. But we had constant contact up until December 10th. She talked to us all the time. She asked us to do things. I took them to the emergency room.
For sure, Ed.
Let's see, we had her aunt down here to have dinner. Lucia, her friend, was down here to have dinner. We spent Thanksgiving with them. I went to the pumpkin patch with her and Isaac. We went on a beach trip for his birthday. We spent most of the summer in the pool together. But, you know, all of a sudden now we're stalking and the grooming behavior, that's just disgusting. And if she had these
Grooming
concerns about us,
behavior?
why was
Accusing
she in
them of,
contact with us on a regular basis?
boy.
Why
Grooming
was
her
she,
son.
you know, giving us
boy.
access to her son? We were spending time with both of them.
That's next
We have
level.
never asked to see Isaac by himself. The only times that we've been alone with Isaac is a couple times babysitting for her when she's going to get her hair done. We've always invited Ceci. It has always been Ceci, Isaac, and Rugby invited in all things.
Oh, what a cast of characters.
So, yeah, Rugby's the dog.
Okay.
Oh.
I heard the 80-year-old
so-
speak in the background.
What do you, I'm sorry, I don't know what you want me to read specifically. Okay.
What'd you say?
So,
Brother Babaluya, thank you.
Okay.
Hallelujah.
Okay, this is Melody now. We mentioned that Ceci made many false statements. We do not believe anything on the document adds any
Most judges will make these people get on camera, you know?
Yeah.
of harassment.
All of them are laying
So
low.
since December, so on December 10th, there was a falling out of sorts over the cupcake. And after that, she came down and said, we will talk, but I'm not ready right now, when she came and got Isaac's trucks. We didn't talk to her again until I told her I would email her. We ran into her outside and said hi during Christmas. Mom sent a
thank you.
picture, but she had never said anything about,
Thank you.
I don't want to be friends. She never said, I don't want you in our lives, leave us alone. The first time she said anything was on the email when she said, please do not approach us. And
This isn't even as
I
bad as what we
answered back
saw
on that
last
email
week.
and I said, I'm not
Believe it or
willing to
not,
feel
no.
uncomfortable in my own home that if we saw Isaac, we would not, we weren't trying to see Isaac, but
Here's
have
said
you seen the
From
the
best I
picture
could
of the stairwell
figure out from what they said.
You have to
towards
tell me
the
where it
end.
is, because I've got about 100
Sorry.
pages that you submitted,
It's
so.
towards the end. of
100
the
pages?
Okay, anyway, so I think in the time that she moved out from December
see what
10th, we saw her like 4 times. The time that she was talking about my mom crying because Isaac was there is ridiculous. I think I've seen my mom cry 5 times. I was also with her. We were on our way to the doctor, and we cannot get to our car without passing right in front of her car. And again, at that point, I think it was at that
Yeah,
point
Shanta, we
I
can do
even
that.
talked. When she might have said that please don't approach, but then when I emailed her again and said, okay, so let me get this straight. You want me to ignore your son if I see him
Give me a minute. I'll put it
and
in
treat him like we don't know him. And you want to, I basically said, just because we're not going to be friends, it doesn't mean we have to act like children. It's not that hard to be cordial. And she said, yes, we'll be cordial.
Fight over a cupcake and some old lady
said,
grooming
"Don't
a
approach us."
kid. I think.
She
Quit
said,
grooming
"We'll
that
be
youngin'."
cordial when we see each other. But she's saying that she was saying, leave us alone. Don't talk to me. Do this. She didn't. Same with the
Can't do it
stalking
all.
and harassing from April. If
Yeah,
she
did they get
wants
rid of
to bar somebody from talking to her,
Do they?
or
Yeah.
tell somebody
Immediately.
that she needs boundaries, she needs to actually say that, as opposed to making boundaries, I guess, in her head.
They're cult.
And so
Sasha.
if she tried to distance herself, she certainly never told us anything about it.
Been practicing off
So I'm trying to remember what
I'm a winner.
What exactly did you get from that email on the 4th that she sent? Went to.
what did I get from the email on the 4th? Sorry, let me
Yeah,
pull
you're
that.
saying that she never really told you she didn't want to have contact from you.
All she said was, please do not approach us. And so I emailed her back. So, okay, so on December 10th when we talked, or December 10th when we talked, she made it sound like we were going to talk later. I thought that this was a friendship that we've had for 2 years. It's been a very close friendship that was having problems, and we'd figure it out.
Figure it out.
On January 4th, let's see. Let me look at the email. Okay.
Please like this video.
So on
Thank you.
January 4th,
I dropped the link, but keep in mind they get rid of their videos right after it, and
I'm trying to find the right one.
It's only on Fridays.
but he does court all week.
Yeah.
I know, okay, I'm pretty sure that what you're talking about. She said, please do not approach us outside. We haven't approached her. We live right next door to her. We can't be out there without seeing her. And then after speaking with her and her saying that, I wrote her the email and then she said, yes, okay, that's what we'll do. We'll be cordial. So from not saying anything and then now saying that, you know, she was trying to distance herself, and all she said was that she never ever said anything about don't talk to us.
Don't talk to
She
me.
said, please don't approach us,
Your
which
cupcakes
we
suck.
saw them maybe 4 times in a matter of months. And it was all just outside on the way to the car, coming and going. We were not trying to see Isaac or her.
Don't stay
It's a
so
shared
close to me.
stairway. It's kind of hard if she comes home and I'm leaving, it's hard not to. So let's see. The other
These
thing
weren't
was,
planned attempts. These were just
so as far as
coincidences
the
for you.
stacking and harassing, also she claims that
She say
the
stacking?
police told her that, you know, she needs to take
May have
these
said it.
actions. The counselor told her she needs to take these actions. The domestic violence person says she needs to take these actions. They're saying that based on what she's telling them, which is not the truth.
Delivering the goods.
She's taking
Red
things that
velvet
I've
flusher.
said and turning them around, or that mom said, and turning them into something that they're not. We never said anything about, oh my gosh, Isaac's going to have a hard time if we're not in his life. We were talking about, okay, so the the thing about the not punishing us or not using us to punish him.
It's true. I'm kind of surprised they have Chad on over there.
We weren't saying that that he had to see us because he shouldn't feel punished. And okay, also let me preface this by, on a regular basis, we spoke. She constantly told us about what was going on with her husband, about what was going on with Isaac.
Hey, Lynn.
I went to the emergency room and sat for 12 hours with him while he was in there because he was ticking.
Stalking and
And they
harassing.
decided it was
JJ.
behavioral issues. The doctor did.
He was
And so
ticking?
we talked after that about the behavioral issues and things.
Ticking?
She asked my opinion a lot about a lot of things. So if she didn't want an opinion, again, all she would have had to do is say that. And I put that in the note. You know, if you want to set a boundary and say, I don't want you to talk about my son anymore, tell me how things are, what you think. But she didn't do that. She has always asked me for my opinion. We've talked about all sorts of things. The communications that are at the end.
Yeah,
of the
this lady didn't
document,
help at all, I don't think, in this
No, this
situation. Like,
it just
I don't,
muddied the
That's just
water
November
even
and
more.
it made it even
December
worse. I hope that he has
and
some
it's
questions.
just one
He's ready
one line of
to talk.
communication between my mom,
He's just kind
Ceci,
of just
and me.
flipping through the 100+
There was
pages.
also messages between me and Ceci and mom.
Mom and
We
Ceci
have
too.
recordings,
Cupcake,
or not
I
recordings,
guess.
we have like the documents like that back till, you know, April or March. But we didn't want to put all of that in here because it would have been overwhelming. It already seemed overwhelming.
Yes, it does.
Talking to us on a regular basis, not communicating that there's any problem. And I said in there, you know, if you had wanted to distance yourself or say that, you know, you
We all
don't want
are.
us to do this, even though you previously asked us for our opinion and previously asked us to step in. All she had to do is say that, but she didn't.
Are you done? For
Okay.
God's
Now,
sakes.
this is Melody. There's an instance where she said I threw a ball at her.
Shut
up!
The balls all fell down on the upper floor. They're wiffle balls. So one fell down on the bottom floor.
A wiffle ball
and
now?
I tried to throw it up to her, but a wiffle ball just doesn't do it. So it went about halfway out. But I certainly didn't throw something that could hurt her. And I smiled while I did it. Here's your ball, because she was picking up all the other ones. She's accusing me of being racist. And
Go. All right.
there's nothing in here
I
that
see it,
she
Nelsie. I got it.
is saying where she's explaining what she means by that. I'm not racist. And all the letters
Obviously.
that
That's the
I
door to the
have
racism.
from different people that have known me for 40 years and up, they're all very clear. I am not racist. She gets things
But
in
you know
her
that you're
head.
reading this piano.
There's a lot of statements she makes with emotion and her interpretation of what I mean. When I say something, she doesn't get to interpret what I really mean. And we're seeing that through the whole thing. Let's see.
It's gonna happen. You just have to accept it.
Yeah,
I don't want that.
We've gone back completely. So, do you have any questions for us?
I do have one question. There was in the petition, Ms. Skullroot talks about, it says that her aunt told her that, I'm not sure if it was Colleen or Melody or both. Were
Melody,
trying to,
yes.
like,
The
find
the
her.
bowl
Can you
was
tell
a
me about
ball.
that?
Her aunt was here for dinner.
A wiffle
The only
ball.
communication I've had is, it's actually on the back page, but I can tell you it says.
Back page.
Clark County, Washington.
Hi, Colleen and Melody. This is Gladys, Ceci's aunt. Thank you so much for an enjoyable evening. The food was delicious. Kind of you to let me have your books. My phone number is, if there's ever a need or an emergency, or you would come to Las Vegas, please call. I didn't notice it at first. I then replied, nice to hear from you. Ceci oh, sorry, that's her answer.
This is your
Mine
answer.
is, my answer to her was, I heard you had a bad trip back. Hope you are feeling better now. It was really nice to meet you. We do get to Las Vegas now, so we'll maybe be able to see you. We haven't seen much of Ceci or Isaac since you left.
Creed frame.
They were sick for a while, but now there seems to
Dolphin
not
fan
want
did
to
that.
do anything. We sure miss Isaac. She texted me back and said, nice to hear from you. Yes, Ceci likes to hide for a while. Her mom tells me she's done
Who
that
keeps
since
a
she was
note like
child.
this?
I know she's
Who?
getting ready to go to court for the police report she filed. She gets very overwhelmed by stuff like that. I also know she appreciates your friendship and or support, excuse me. You'll see them soon enough. And yeah, that was the end of it. I sent back, thank you for letting me know. That was, it was really upsetting me. That is the end of it. We don't interpret it that I was chasing
Jeanette.
her aunt or I was doing anything like that. Her aunt contacted me.
And that was that sometime last year?
August 15th, August,
Yeah.
around August
Mhm.
15th. So, also she's asking for this petition based on something she thinks we might do. We haven't yet done anything. She even says,
But
I
we
think that
will.
they might
I'm
go
telling
to
you.
his school. We would never try to see Isaac behind her back because it would be upsetting to Isaac and it would be confusing to him.
And it'd be against
And
the
even
law.
based on the report that she put in there about him asking to talk to me and her saying, no, stay away from her. We don't want her near you. He's already confused enough. We don't want that for him. She's also making it sound like, sorry. She's also making it,
Sorry.
I think
sorry.
she just heard you
She's
laughing
also
at her.
making it sound like this was a casual relationship that we're just neighbors. But of the last 2 years, we saw them on a very regular basis. We celebrated holidays together, Christmas, Thanksgiving. This year we were planning Christmas since about April.
Good
And,
Lord.
And
Wow.
we made sure to be here for Christmas because
And now
this
you're
was the
sitting in
first year
harassment
that
court
she
on the
wasn't
first day
gonna
of
have
April this
Isaac,
year.
and he was going to be at his dad's house for Christmas, and we didn't want her to be alone on Christmas. She bought mom a Grateful for You Nana mug and me an aunt keychain.
More of a conversation at this point.
She told us
A little
that
more conversation, a little
thought
less
of
court
Mickey,
here.
my mom, Melody, as a
This
grandma.
is why I love
It wasn't
harassment
a
court.
casual relationship. We spent a lot of time with them and were treated and acted more like family members.
Remember how she was
than-
saying that the lady
just,
read more
you know,
into the
a
message
simple
than there was?
hi
Now
bye
she's
with the
reading
neighbor.
more into this relationship slash
You know,
friendship than there was.
We spent most of the summer in the pool with them.
I bet that was hot.
Okay.
Also, this is Melody now. In several instances, she has said I have yelled at her.
I haven't yelled at her. She said I yelled at her in the car on an instance in May. And if you had a chance to listen to the audio, there is no yell. I didn't do any yelling, but she yelled at me and she cut that audio off before you could hear any of that. It ended.
You're saying it's been
I have
altered?
never said that she owed me to see Isaac. I have said, Isaac, what I actually said is Isaac is a child of God. I will not ignore him. When I see him on the street, I will treat him like I would treat any other child and say hello to him. I would not just walk away
I
from
love the
him.
question
That
about
would be
the outcome.
cruel.
Yeah, what do we want to?
Like we told Ceci, we're not
Between
going
them.
to play games. We don't want any drama.
She wants
We're just
she
gonna
wants
act
some
like
sort
normal
of
people. Come and
judgment
go, hi,
where they
bye.
can't speak
You know,
to
we
that.
weren't
Like it'd
trying
be
to
against the
make
law and
such
have them
laugh
arrested.
that
Yeah.
wasn't there. We just didn't want to feel uncomfortable in our own home and hurt his feelings or feel like we,
Ozark's one of my favorite shows.
couldn't just say hi
Great
like
show.
adults. And, it got to the point where she was hiding in her car if we were outside, and it was very uncomfortable. And when she moved,
He's very
though there's a
patient.
small part of me that was
Hiding in
sad,
her car.
we were
Are there
finally
any
at the point
texts with
where
a
we're
lot
like,
of
okay, we can breathe. This is
explicitives?
done.
Let's
The
go.
ordeal's over. We don't need the stress. They've moved. It's done. It's gone. And then we got this restraining order.
Thank you, Kira.
She wants us out of her. Go
When
ahead.
did they move?
Moving
very much so.
was, let me see.
February 19th.
Yeah.
What was the date again? I'm sorry. I didn't
Ooh,
catch it.
February
Rick, I'm
19th.
pumped. I'm pumped.
Have
So-
you
Oh, sorry. Go ahead.
have you had any contact with them since February 19th or seen them?
No, and I
I-
have no desire to. Like I said, there's a little sadness for a friendship that was, I thought, strong, but we were finally getting to the point where we were okay, and the stress was gone, and the awkwardness of feeling like, she's hiding in a car. She was one of my closest friends for 2 years, and then within a matter of like 2 months, when we only saw each other 4 times, all of a sudden she's acting like she's scared of me, and she still hasn't said what I've specifically done or what Melody has specifically done. We've never yelled at her. We've never raised our voice. She's snapped and
I
raised her
think-
voice at us.
I don't think she has to give you a
I've
reason
never
for not
gotten in her
liking
face.
you.
Even when I did have
I don't think
something to
life
say
works
about
that
her, I was doing it as I was walking away.
How
I've
dare you
gone
not
out
be
of
my
way
friend?
because I knew that she had an abusive past. I've gone out of my way to always be very careful in the way that I spoke to her and give her, we did an email as opposed to talking to her face, because I didn't want her to feel threatened, or I didn't want her to feel attacked, because she's said in the past that she feels attacked when she doesn't communicate very well. And so when anybody tries
Welcome
to
back.
communicate, she feels attacked.
You've missed so
Um,
much.
As far as, they left, and like I said, it was nice, and she wants us to be out of her life so badly that she's doing this. But the only reason we're in her life is because she's doing this.
Mikey, I'm right at twat court
I'd like to
there.
move
I
on
gotta
with my
run
life.
up.
My mom does not need the
I'll be
stress.
right
She's 77 years old. She has bad health. Ceci knows this. It has not been good for her. We do not desire to have her in our life, and we would never try to make Isaac. We wouldn't do that.
Okay.
Okay, that's
I would
enough.
see.
Isaac, she makes the
I'm
decisions
just
for
gonna
Isaac.
cut you off at this point. So both parties had ample opportunity to speak and also submitted both parties have had a chance to submit a substantial amount of material. And I've reviewed all of it. I've heard from the parties, and I'm just gonna make a decision at this point. So it appears to me the parties had a good relationship. Something happened, or maybe it wasn't a good relationship looking back on it. I mean, clearly at this point, it seems like maybe that was not a good relationship. I don't know. The petitioner didn't want to have any more of a friendship with the respondents, or to have the respondents contact the petitioner's child. I think they were surprised by this. Maybe they shouldn't have been. And I mean, that January 4th email to me is pretty clear that she doesn't want to have any contact with the respondents anymore. And I think it's just hair splitting to say, well, don't approach me doesn't mean don't have contact with me. It's the same thing. I mean, that's what's clearly, I think, what she is asking. That being said, one of the parts of the definition of harassment is that there has to be a course of conduct, and that course of conduct has to evidence a continuity of purpose, meaning that it has to show that it's the purpose of that course of conduct is harassment or something akin to that. And I just don't see that that's the case. Since they haven't repeatedly harassed or followed the petitioner or child. I know the petitioner probably feels that they have, but just objectively, it doesn't seem that way. And at this point, they're clearly, I notice the petitioner doesn't want to have any contact with her or the child.
Isaac is the little
Petitioner's
kid.
Moved somewhere else along with their child. The respondents, I don't think, they've told me they don't have any intention of contacting the petitioner's child. I just can't see that. I don't see that happening. Maybe I'm wrong, but that's what I'm getting from them. And it doesn't seem to be the case that they're stalking anybody. In fact, they haven't had any contact
Thank
since
you, guys.
February 19th. And this was filed, I think, shortly after the petitioner had contact from her aunt, who said that the respondents had some contact with the petitioner's aunt, but that was in August. And it doesn't seem like it was anything weird or stalking. But that was, I think, the catalyst for filing this. But I'm not going to find this constitutes harassment or stalking for that matter. So I'm going to dismiss the petition. That being said, I would advise the respondents not to have any further contact with the petitioner or her child. Clearly, she doesn't want that. And I say that at this point, it cannot be argued. I guess you can argue whatever you want, but reasonably argued that the petitioner wants any contact from the respondent. So Ms. Scullery, you do have the right to appeal my decision. If you'd like to do that, you can check with District Court Administration. They can tell you how that process works. And if you'd
And
like
it's
to,
going to
you're
be
not
the
gonna hurt my
same
feelings.
decision.
I will tell you for what it's worth, though, that if you have any further contact from the respondents, or if they have any contact with your child or attempt to, I'd say you'd probably be in a good position to refile that petition. But from what I've heard so far, I just don't think the evidence does not support finding of harassment or stalking.
Okay, Commissioner, I do have one question. What about if they tried to contact my ex-husband? Because they did make threats about that.
I mean, at this point, I'm not going to order them to contact or not contact anybody. If it seems like they are stalking you or trying to seek contact with you through a third party, I mean, you're certainly welcome to file a petition. We can revisit it. That being said, to the respondents, Melody and Colleen Mayer, I would, like I said, I would just stay completely disconnected from the
They're also
petitioner or her
not
family,
allowed to
because
come
clearly
within
she's not in
100
contact with you
feet
either directly or
of a
indirectly.
wiffle ball.
Like I said,
Absolutely.
I don't think the evidence isn't supported. So, but any questions about that?
I do have a question if I can. So one of the things that was really upsetting about this was that she's called the police twice on us and we had no knowledge of it. And also this petition, because it hasn't been put through, is it still going to be on my record?
I mean, there's always a record of it having been filed. It's not there's not an order that's been entered. It's not a criminal matter. I mean, it shouldn't present any kind of impediment to anything.
Wouldn't it be great if we could send him like a dozen
Okay.
cupcakes and just tell him how much we
Great,
love
thank you.
harassment
That's
for?
what I was worried about.
Okay, yeah.
This
All
could
right,
have been
thank you.
settled in 5 minutes.
Yeah, there's no
Thank you.
defining things that happen that just,
No.
screams that you've been
Harassment
harassed
or stalking. Yeah.
Yeah.
They
Thank
moved
you guys,
away.
for the likes. Very important on the channel. It helps us out so much. You have no idea. That's why we're constantly begging.
Look at us.
Hello,
just
Rachel.
Jumping right into the next one. Here we go.
Okay, there we go. We're just waiting for David's iPhone, who I assume is David Gaddis to connect. So.
Oh, that is cool. All right. So fingers crossed to start praying now for a live chase this weekend and we can hit 8K.
Yeah. That's what we need.
Nice. That'll be a nice thing.
David, former lover of Rachel.
Oh,
I'm
this.
sure.
I'm already telling you, it's going to be a good one.
All right, and Mr. Gaddis.
Take your
can you
pants
hear us
off, David.
Yes, sir. Okay, great. All right, so I have both parties on, and
David's excited to see
yeah,
Rachel, I
thanks for
think.
your
He can't even
patience
look at the
today.
camera.
A little bit longer than I would
Can't
hope
look her
to
in the
get to,
eyes.
So I apologize for the delay.
He's going to be the one that's claiming she's
Swear both
harassing him.
parties
What do you
in.
think?
Raise your right hands, please.
Nah,
Swear
there's
or
no
affirm the
way.
evidence you about to give should be the truth,
Oh,
the
I
whole
think
truth,
so.
and nothing but the truth.
Mouth
I
breather.
do. Okay. And let me take a look. Make sure I didn't miss anything.
Abby, if you scroll up, I actually put the link in there. Harassment court is only on Fridays,
So I read
though,
over
and the
petition,
videos are
and
gone
I'll have that
instantly.
open
So
in front of me in just a moment. I took some notes as well.
Yeah, he burns
And I
them
read
just
over
like
Mr.
this, one
Gaddis's
after the other, after the other.
yeah, we do. I'm still saying that he's claiming Rachel
Ms.
harassed
Kelly,
him, not
if
the
you-
other way.
Are you, is it, would you prefer Ms. Kelly or Kelly Smith?
Kelly Smith is fine, thank you.
Okay. So Ms. Kelly.
Let's check
Smith,
my
I read
calendar,
over
what's
your
your-
petition, and if you'd just like to walk me through it, you're welcome to do that, or if there's anything you'd like to emphasize, or, whatever you want to tell me is fine. And then Mr. Gaddis, you'll have a chance to respond as well.
Everything that's in my petition is everything I needed to say, so I need to go through.
And so there was Mr. Gaddis is your, I guess, biological father. Is that accurate?
That's correct.
It's her dad.
Okay. All right.
And at some point,
I think I was wrong.
I just want to look over the emails that you submitted here.
Oh, hell. What did you do?
Now knowing that, Dave, your comment is
Really out of
Really out-
line, Dave. Come on. It's a father, man. My God.
Well played, by the way. I don't really have anything to say other than all the stuff that I already gave you. Judge. So
what do you bring your dad to court for?
And maybe it's too big of a question, but where all this came from? I mean, because the emails that you submitted, I mean, arguably are not particularly pleasant.
Oh, read them. For God's sakes,
you know he'll read them. Some of the most
It started over in the summer. My parents separated, and then my mom filed for divorce, and I was trying to mediate with that as well as my sister, and I stopped responding to David's emails and texts several months ago, and then they continue to come in. They seem to be escalating, and so I just really I have it blocked on my devices and my email, but it's been a lot.
Did you at some point, I'm not saying you necessarily have to do this, but did you at some point tell him not to contact you anymore?
I let him know several months ago that I would not be responding to any more emails and texts. I don't know that I specifically said, do not contact me, but that was definitely the gist of the communication.
Okay. Anything else you wanted to add?
No, thank you.
Did you like extra mashed potatoes? No, thank you.
And then Mr.
I like how she played this though.
Just 1 second.
Her thing is basically like, these emails say it all, Your Honor.
Yeah. What she submitted is it, and there you go. I'm guessing that judges don't have a lot of time before seeing these cases to really get an idea of what's happening.
Oh, I'm sure it's very quick look over the cases.
Yeah, that's a small ass place. Imagine how nice her mom's house is, considering where Rachel's sitting.
It's not really a timeline in the petition, but, and I see that you filed this March 8th, I think. Is there something in
Day after my
particular that
birthday.
prompted you to file this? I want to make sure I'm not missing anything. It looks like the last email I have was from February 28th.
Yeah, I had gotten the last email, which I felt was alarming. And then I just got a communication from other family members that seemed to indicate that things were escalating. And so I just, it's been super traumatic having these things just pop up while I'm with my family and I'm at work. And my lack of response to all of it, I feel like should have been an indication that, that communication is not obviously a conversation. And so since ignoring these emails and texts for months has been unsuccessful, I just really needed to stop.
Okay, understood. Okay, Thank you. And then, Mr. Gaddis, anything you'd like to say in response? And
Shocking.
and
He needed
ready for your
some
response.
chapstick after all that
I
mouth.
just want to have that in front of me. If there's anything you'd like to refer to, you're welcome to do that.
Nothing in particular. I summarized my position in the section to the court. That's a summary on the front.
I wrote 3 sentences, Your Honor.
I think the case lacks merit. I think it doesn't have nearly enough evidence to justify the claim.
Did Ms. Kelly Smith ever, she said that basically she told you she wouldn't be responding any further. Did you, first of all, do you recall her doing that at some point, or was there anything from her that indicated to you that she didn't want to hear from you anymore?
Well, she said that she would not be responding to my emails anymore because she didn't think they were worth reading.
Do you remember when that was?
No, I don't. I was never told to stop.
It was right after
I was never
email where
told
I
that I
called
was
her the C
harassing
word,
her.
Your Honor.
I was never given any hint that I was harassing her.
She definitely didn't get her looks from Pops.
Is there, I'm just looking at the emails, and I don't think there's any dispute about the content of them necessarily, but I mean, was there a reason you kept sending them, or?
Yes, every email that I sent to her was sent for a reason. It was never a planned thing where I just felt like harassing her. It was always because of something that had happened, something that she had done.
Purpose.
And what sort of things did she do that you think merited those emails?
Well, if I was asked to give the full context of the thing, I do have that somewhere. I don't have it in front of me right now. Why did I send each of the emails? If you look on the page 2, where I start to address specific issues in the response.
Okay.
So this is February 2nd. So this is a discussion.
Go
All
ahead,
right.
I'm sorry.
So this is a discussion of why I didn't have a son, what my theory on why I didn't have a son. And this has to do with my spiritual beliefs and the way I was raised by my father. The quote, it was misquoted. I pasted it in below so that you can see that it was misquoted. You can see specifically exactly what I said.
Well, tell us. We'd like to hear.
And my note is that I was simply stating my opinion on the likelihood that God is not really going to be super happy about her behavior, and he's going to probably punish it. And I, as her father, believe I have to say that. In addition to the fact that the thing is misquoted. And from 2 emails.
Oh, she's going to hell for something. And he's mad he didn't have a son. That's what I've gotten so far.
The February 1st email was from myself to my former spouse, was not directed to the petitioner. How is this an instance of me harassing the petitioner?
Is that son? Is that who you're talking about?
Yes. Yes, sir. And you can see the quotes on the following page. I have quoted.
We are not
the
entirely
lines
sure,
so that I can
Jeanette,
refer
because
to them.
she just
This
kind of
emails
passed
from
off.
the response
Everything's
to a
in
third
the.
party. Where is the petitioner even mentioned?
She's suing him for harassment.
Where
We know that
enemy
much.
is used is the same as
Yeah.
adversary. It is in the same context as sense has been the case all along, legal, in the legal sense. Responding in third party of the same faith and read the same Bible, I am expressing my opinion to her, my former wife, regarding spiritual matter. And in number 5, a statement is made to the coward. Again, repay is in the legal sense and not in the financial sense and not in any way physical. How in the world am I being accused of potentially violent harassment?
Potentially violent.
Easy does it, Mr. Leahy.
Based on this?
I am the liquor.
Oh, T, that.
I thought that too, T. That came into my mind too.
Mm-hmm.
Okay, well, with that, so the definition.
Was it
of
the watch that
harassment,
gave it away?
Both parties, I'm sure I've read it. It's a knowing willful course of conduct directed at a specific person which seriously alarms, annoys, harasses, or is detrimental to such person, and which serves no lawful or legitimate purpose. And shall be such as would cause a reasonable person to suffer substantial emotional distress and actually causes such a substantial emotional distress. And in looking at whether a course of conduct serves any legitimate or lawful purpose is a number of things to consider, but maybe
yes,
it's whether the conduct has been initiated by the respondent only, or is it
Yes,
by both
Sarge.
parties? Whether the response be given clear notice that all further contact with the petitioner is unwanted. The response course of conduct appears designed to alarm, annoy, or harass the petitioner. Then there's some further things I don't think necessarily apply in terms of
Either that or
conduct
she had some really sour Sour
I mean, this
Patch
is a
Kids.
family member, I suppose, arguably, but that's not the context that is in the statute there. So, I mean, looking at the content of the emails, I mean, I think anybody who would receive this from a person, certainly a family member, would be suffer substantial emotional distress. None of these things are nice; they're all quite nasty, and there's really no lawful or legitimate purpose for sending those communications. And it
Can we have an
certainly seems,
example, please?
that the course of conduct is designed to alarm, annoy, or harass the petitioner. In this case, Ms.
Look at that dumbass look on his
Kelly
face.
Smith. So
I disagree with that, sir. And you haven't heard all the evidence. You didn't let me go through all of my evidence. I disagree with your determination. There is a
what other
purpose, and
evidence
it's
do you
in
wanna
my
go through?
response.
I asked you, and you said no. Everything's contained in your writing. But if you have
And
further
we
evidence,
have
go ahead.
not, we have not gone through the entire thing.
Well, go ahead. Tell me what you want to tell me. Go ahead. I'm all ears.
Like, in other words,
In
keep
the
talking
February
and just hang
22nd email
yourself.
to the petitioner, I said plainly, you three had ample opportunity to be civil, warm, kind. You three chose the opposite. You three have begged me to
Yeah, she's
retaliate,
crying.
and I will. Is that harassment, sir?
That's a threat.
I don't answer questions. I only make findings. So if you
Okay.
want to argue something to me, you're welcome to do that. And maybe that was a rhetorical
All right.
question. Misunderstood
All
you,
right.
but continue.
All right. The petitioner seems to imply throughout this case that the respondent is bent on revenge, as in physical revenge, as in violence. And this is wrong. This is completely wrong. I have never been a violent person. There's no indication that I have ever been a violent or never would be a violent person. This is in this email is in no way a threat or harassment. It is simply a declaration of my intent to retaliate in a legal sense.
That's a
In
threat.
the January
Retaliate
19th, sense,
legal sense. What do you mean?
retaliate in the legal sense. Retaliate by using the courts to address my issues with the petitioner. There's a long-standing issue and it will be addressed in court. And that's the way I'm going to do it, and not by use of violence. And I really resent the fact that she has accused me of being a violent person, and I am not a violent person. And my civil rights are being restricted because of the potential for violence. I have a business partner that lives within
Okay. Go ahead. I'm sorry.
Go ahead, you
I have a
jackass.
business partner that lives within 300 feet of her house, of Rachel's house. She saw me park there. I don't know why she would be alarmed by that. My business partner's name is Isabel Hoa. She's willing to participate in this. There's nothing nefarious about me being parked there, but I haven't been able to see my business partner or do any work with my business partner for this whole duration because I am assumed to be a violent threat. And I resent that deeply, and I will take care of that in court.
Gosh, he almost looks like it, Jen. Remember that?
Mm-hmm.
Well, I'm warning them
That is
my
him.
intent to take legal action in
is-
retaliation for
Jen's
their legal
100%
action.
correct.
I think so, Jen.
Because now Rachel looks
Damn.
familiar.
And by that
Damn,
includes
Jen.
this case right here, because I don't believe I've been justly accused. I think I've been unjustly accused, and I will address this in a separate court.
Oh,
Oh, she just took.
I'd like to skip forward a little bit to number 7, question number 7 in my response. May I proceed?
Go. Tell me what you want to talk about.
Judge is
As a
having-
respondent,
I-
you displayed or
Are you just gonna read everything that you submitted in writing, or is there anything in additional that you're gonna tell me?
I will tell you that the petitioner
Judge's body
is
language, boy.
using
Oh.
innuendo and non-answers. The
You ever
answer to
seen
the
him this
question
pissed?
is no.
Seriously?
She knows the
No.
answer to this question is
Never.
no. And then she proceeded to give you a bunch of innuendo that suggests that I'm violent. That's a problem for me.
God will
Yeah, it's
beat your
something
ass,
wacky that
Rachel.
he's
Whom he
not-
loveth, he chasteneth. Does God love you, Rachel? That's in an email that you sent to her February 2nd.
That's correct.
What's your lawful or legitimate purpose for saying anything like that to somebody? Just tell
She's
me
my
that.
daughter. She's my
That
daughter.
is not a lawful.
I was
legitimate- I've read your response. You were simply going through the response. Is there anything you'd like to say in addition to what is in your
Abby, I
written
believe
response?
last week this guy showed up late and there was a little bit of an altercation.
Thank you.
Yeah.
I'll
They had
find
to
that the
beat him.
petitioner has been harassing the respondent. It is without question that's been happening. The respondent has clearly been severely affected by the petitioner, rather than severely affected by this. I'll note for the record, she is visibly upset. And I'll enter an order that you not have any contact with her directly or indirectly. Do not keep her under surveillance. Don't go within 300 feet of her residence or workplace. If that means you have to meet your business partner somewhere else, so be it. This order will last for 5 years. I think a longer duration is
5 years.
is warranted in this case. The reason is that there's apparently going to be some continued legal action, and the petitioner's speech to his daughter has been so unpleasant. And I suspect this would go much longer than a year if it were to allowed to just go a year and expire. So I'm going to have it go out 5 years. The expiration date will be 2027, so April 1st, 2027. Petitioner has the right to appeal. You can check with District Court Administration. They can tell you how that process works.
Did you mean the respondent, sir?
The respondent,
Appeal.
yes, sir. You have the right to appeal, yes, sir.
You
I'm
said
sorry,
petitioner.
misspoke. I know what I said, and I misspoke. We're done. We'll send you we'll mail you.
I know what I
a copy of
said.
That order. We'll email a copy to both parties as well.
I know what I said.
You may disconnect.
In other words, David, go fuck yourself.
If I could figure out how. There we go.
I really do feel bad for Rachel in that one for sure. And harassment court, I believe, is
It's calling it a
Finale.
day. Wow, what a
Uh,
case.
We are go. That one's gone. This one was a weird one that I seen pop up, and it was Volkswagen clean diesel litigation over at Travis County.
Okay.
Yeah, no group hug for Rachel. No kidding. Seriously, that
Poor kid.
not bad. Not bad.
Having to put up with that is ridiculous. It really is.
Harassment court's amazing though. Anti-harassment court, excuse me. I did put in, if you do exclamation point harassment, if you can spell it right. Took me 2 times.
Well, it's
We'll bring
okay,
up the it'll bring up the link.
I do have the beginning of harassment court. There was a case we didn't hear.
Oh, really? Yeah,
and I
let's
can
do
try
that.
and get it to play. I've got it queued up, so maybe it'll play. We'll see. Fingers crossed.
5 years. That's good. Jen, seriously, a round of applause for Jen. You are his candor just had changed that day too when he was late and he
just
said
showed
his
up like
piece. And wow, yeah. Man, that judge was
sorry, I
not
had to
happy with him. Nope, take
reset
your time.
StreamYard.
We'll jump over to Collins for just a second just to see what they're doing.
Understand those are the elements.
Yes.
By pleading guilty, you're giving up the right to a speedy public trial in front of an
What's
impartial
that?
jury.
Is
You're giving up the
Maxie
right
got
to
a fang?
You're giving up the right to hear and question the prosecutor's witnesses. You're giving up the right to testify on your own behalf. You're giving up your right to be presumed innocent. You're giving up your right to appeal from a determination of guilt. Do you understand that these are your trial rights and you're giving them up by pleading guilty?
Yes, Your Honor.
Okay. The maximum sentence potentially here is 364 days in jail, 10,250 in fines and fees. Is that your understanding?
Yes.
You understand that the prosecutor is going to be making a recommendation of 3 days in jail, 361 suspended, those 3 days in jail, converted to 3 days of out-of-custody work crew or 24 hours of alternative community service monitored by offender services.
We don't know,
And I asked
Sarge, because the way she
additional
played that off very
I'm
well
not
with
going
it.
to
Everything's
hold
there.
check.
You just read it.
Understand that to be their recommendation.
Yes, Your Honor.
He was definitely
He's got
hiding
all-
behind
I'm not
some
bound by anybody.
scripture as well.
Oh, yeah.
Sentence up to the max.
Yes.
Holy rolling.
If you are not a citizen of the United States, a guilty plea to an offense punishable as a crime under state law may be grounds for deportation, exclusion from admission, or denial of naturalization pursuant to the laws of the United States. You understand that that's a potential.
Yes, sir.
Okay. Then to the charge of theft in the third degree, how do you plead, guilty or not guilty?
Guilty?
You're making this plea freely and voluntarily.
Yes, Your Honor.
If anybody threatened you to get you to plead guilty,
No, sir.
if anybody made any promises to get you to
I'm not sure in this court if we're going to
Other
find
than
out like all the charges or not.
prosecutor's
So
promise
we'll hang out for
recommendation.
2 seconds and then.
No, sir.
I have a statement here that says that instead of making a statement, you're asking the court to review the police reports and or probable cause statement. In this case, in order to determine and establish a factual basis for this plea. Is that what you want me to do?
Yes.
That was
maybe.
Yeah.
My understanding is that you do not want to admit guilt, but you do want to take advantage of the prosecutor's offer. Is that what's going on?
Yes, sir. Yes.
Okay, very good. I have had a chance to review the probable cause statement, and I'll make a finding that there is a factual basis to support this plea and a finding of guilt, and I will find the defendant guilty beyond a reasonable doubt. I'll find that the defendant has knowingly, voluntarily, and intelligently entered into this.
Yeah, and I don't blame her, Vicky. It was well played.
Your Honor, we would just request that you follow the agreement.
Just because we normally don't see that.
Yeah, it's, Ms. Grimm.
Yes, this is Miss Campbell's case, and her notes indicate that we're asking that the court impose the time on either work crew or community service or offender services, and that her status as indigent has not changed.
Ms. Brown, is there anything I'd like to say to me before I sentence you?
No, but just since this incident, I've made a better choice in friends and associates. I just got my license back and my SR22 insurance, full coverage insurance, and I'm just.
You have beautiful eyes, Your Honor.
I'll follow the recommendation here. I'll give 3 days in jail with 361 suspended, a $5,000 fine with all of it.
Look at her face.
On my determination that the defendant is indigent. I'll take those 3 days in jail and I'll convert them to 3 days of out of custody work crew or 24 hours of community service monitored by offender services. You will need to call offender services today to set up your intake interview so you can do your community service or out of custody work crew. Now, the suspended sentence runs for 24 months on the following conditions. I have no criminal law violations on any act committed after imposition of sentence today. Successfully complete your work crew or community service and do not enter the building or parking lot at Holt's Quick Check in Kelso. We'll send you a
Well, we know
copy.
where it happened. Holt's
Yeah, no
Quick Check.
kidding.
Contact offender services you can get.
Just about the same here,
community
Carrie. It's
service
fine
time.
with me too.
If you don't do it and they send me notice that you haven't done it,
I enjoy
I'll
that.
not only convert the 3 days back to jail, but there's a good chance I'll unsuspend some of that time. And,
Am I able to contact them tomorrow, or do I have to do that today?
tomorrow will work. Would you
Tomorrow
like their
will work.
number?
Okay.
Tomorrow's
All right.
Saturday.
Would you like their
Tomorrow's
number?
Saturday.
Oh, that's right.
Yeah, Monday's fine.
Monday is fine. Yes, I would like her.
Okay, 360
Uh-huh.
577
Yes.
3118.
You're a hot chick.
Okay.
Nice.
Very good.
All right.
Okay.
Thank you, Your
Give
Honor.
us a call.
Congratulations on getting the license back.
Yeah.
Woohoo.
Okay, thank you, Ms. Brown.
She's got a better friend now, and
Yeah, she's
Come
she's
on.
made
Your Honor, I was
way
just-
better decisions.
I
All right,
know.
cool.
Yeah.
Let's see if this will play. Hopefully it will. Well, if not, I'm sorry.
So that'll be admitted. And just, I guess. for
Well,
the
this looks like a
petitioner's
great
benefit,
case
this
already.
is a writing titled motion.
yeah, it's probably why I was going to say I haven't heard. There was a lot of community service
As well
and
as
work
some
stuff with him.
exhibits
Also, it's also Washington
Emails
State,
between the
so
parties and
pretty
for
known to
March for the most part.
kick them quick.
Document for the Air Force Discharge Review Board. Some documents from the U.S. District Court.
I'll be right back.
Go ahead.
I think that was it, more or less. So. Okay, so I reviewed that, and then
You go back and
I
watch
may
it,
have
kiddo.
forgotten to swear the parties in, so I'll go ahead and do that, and then we'll go from there. So if you could raise your right hands, please. Do you swear or affirm the evidence you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Okay. Everybody says yes. And Mr. Shadler, if you'd like to, I've read the petition. I guess maybe just a couple background questions I have for you. It looks like sometime in 2014 or 2015, you were both in the Oregon Air Guard, and there was some sort of administrative separation proceeding that resulted in Mr. Murphy being separated from the Oregon Air Guard. Is that right?
That is correct.
Okay. And you're in, what was your, I mean, I don't need a whole lot of detail, just sort of generally, what was your involvement in that?
Basically, I was the commander of the unit. I was not involved with processing the paperwork or the discharge board or any of that.
Okay.
That was everyone else.
Okay, gotcha. All right, that answers all my questions then, as far as that goes. So if you would like to walk me through, I mean, just address the more recent contact. I think you said it goes back to maybe about 3 weeks ago or so, but you can just walk me through it if you like.
Sure. Around February 20th, I believe, Mr. Murphy contacted me about wanting to do a voluntary deposition. I did give him some dates that I would be available, but I also talked to our JAG and found out basically the procedures need to be subpoenaed. And I let him know that. I repeated that to him in several either emails, conversations that he needed to go through the JAG department. And basically his tone changed because I went through the voluntary deposition to, there was an email about, hey, if you don't do it, you know, something to the extent I'm going to sue you, or, you know, you're going to need to hire a lawyer. And, you know, he's asked me to do a voluntary deposition, and I'm like, now you're saying you're going to take me to court because I won't do a voluntary deposition. And again, I reiterated he needed to go through the JAG. And there's a couple other things that were, to me, hits me as bullying or harassment. And especially when I started getting all the emails at my work email, you know, it was just too much. And then when he showed unannounced, that was a serious concern because we had no meeting planned. It was my place of work. It was a government facility. My supervisor, I was not available at the time, and my supervisor met with Mr. Murphy. He was concerned because of his demeanor, and he's, you know, whether it's true or not, but he said he smelled alcohol on him.
Alcohol.
I ended up calling the JAG and our HR asking for advice. They said, and then there was also Mr. Murphy was getting in and out of his car, like unsure what to do. So at that point, they said, yeah, call the police because we don't want an incident, especially it being a government building. And just as background, a few years ago, Mr. Murphy had contacted me. It was kind of
About joining the
same thing,
Luftwaffe.
got numerous emails from him, and no direct threats, but always vague about, hey, I'm going to come after you, or I'm not going to stop. And it's very discouraging. And I've seen what happened with some of the other commanders, JAGs, anybody in the dealing with this. They're a little bit more protected, some of them, because they're still active military, but me being a civilian now, you know, I really don't want to be hassled like this. And with the fact that Mr. Murphy was barred from coming on base because of threats, not by me, but by, the base commander. All that just added up to a lot of angst and concern. And that's kind of it in a summary.
How many emails approximately did you receive from Mr. Murphy at your work
500.
address?
There was, I saw where once he was blocked, I had probably 10 to 12 of them. And then the day before that, I had, looked to be about 12. And prior
Good
to
Lord.
that, maybe 10 to 15. Again, those aren't exact numbers, but I'm just guessing.
And had you told him that at what point did you tell him we're done here? There's no need for us to communicate anymore.
I did not tell him that, but when I got the email that says, which I included about,
Is Eric scared of him?
hey, I think I have it here.
Is that
You know
March
what?
16th?
Yeah, the one about if you fail to appear, I will be forced to take legal action against you. Do you have an attorney? After that, that's when I blocked him because I was like, I don't even want the conversation. And then talking to our JAG, he said, yeah, you can fully block him from this. You don't even have to have the conversation. I mean, it would have been a courtesy conversation to say I'm blocking you, but I had blocked him in the past many years ago, but the block was gone.
Okay.
That's kind of my guess, but
And it looks like, I'm looking at his emails that he submitted, Mr. Murphy submitted. And there's, looks like it's, actually, maybe that's,
left his only friend though, Tom.
Mm-hmm.
says, Mike, I was contacted this morning by John Trong of the U.S. Attorney's Office.
John Tron.
Was that, do you recall, is that from you? Do you recall? I know you don't have it in front of you, but basically you're saying, or somebody's responding to him saying, the U.S. Attorney's Office says, call them, not me.
Yes, I responded and told him to go. That was one of the emails I responded to, where I said, go through them.
And it looks like you reiterated something along the same lines on March 16th.
Correct.
If you were
Is this
out, if you
all
remember
because
that.
of he lost his
Yeah.
government job?
And that was my attempt
I
to
think
tell him to
so.
stop contacting me, go through them for any subpoenas, whatever you need to do. I did a quick, one file shows I got like 29 emails from him. But I don't think that's everything. I was just doing a quick Outlook search.
Okay.
Calm down.
Is that over what time period is that, if you know?
That one.
2 days.
That's from 2/24 to 3/16.
Okay.
Initially, it wasn't a lot of emails. It was after I said he had to go through the subpoena, and that's where all of a sudden I get,
And he wanted him to go
5
testify
to
in court.
12 in a day on the 14th, 15th, and 16th. That's when I started getting a lot of them.
And then, so he shows up at your place, at your workplace on the 17th. And then I think, I wasn't clear what the date was in the text. When did he text you about that?
That, I believe that was right at the one about, I'm gonna do this the hard way, or what? We're gonna do
Yeah,
this.
that's
That was right after that occurred, I believe.
April
It was that
Fool!
same day.
Good to see you, Mara.
right. Anything else you wanted to add?
I'm guessing.
No, well, I'll
No.
just add, while there's not a lot of direct threats, just the history and what I've seen happen to other people. And, the constant barrage, that's what's causing the issue and the angst. So, and again, I don't want to be hassled like this at my work or private life, and I don't think I should be.
He's all pissed off that the guy he won't.
And then Mr.
Testify
Murphy, what would you like to say in
for him.
response to all that?
Yes, Your Honor. First of all, I don't think Mr. Shather's being completely forthcoming with the court, as I put in my motion. He obviously has the capability to place the screenshots of text messages, but the ones that he put in there were pretty selective. There's text messages I have, and unfortunately, I am not a great screenshot keeper. But even on the 16th, he
Technical
says,
term.
like I said, I have no issues doing the depot. And he said that a couple of times. So what I was trying to accomplish by going to meet with him was to show him paperwork that I didn't want to share electronically, because he was sharing it with an attorney named Brian Leibel, who I am currently trying to get sanctioned by the DCC.
It's a good way of getting in
through
trouble.
Section 1927 order, and also the DC U.S. Attorney's Office. I have a motion pending before the DCC court, which was actually Ketanji Brown until recently, to have them sanctioned and get a default judgment there. So both those attorneys are both very aggressive with Mr. Shadler and trying to get him to not say any more or do anything. They had gotten a declaration from him after his deposition, and that's what started this whole issue, which started out as I thought he was going to be cooperative, and we didn't need to go through, as you know, I'm a pro se, so it's kind of a uphill challenge for me to get depositions and set them up, and the costs. And I'm sure as a judge, you know this, it can be very difficult.
Good point. A little more
So,
serious.
I thought he was going to either voluntarily write a declaration, and that's what he agreed to. And then he got very tentative about that. And then I said, okay, then we both agreed he would do the deposition. And so I paid for it. I set it up, and based on the days and times that he said he had available. And so then, right at the end, he qualified it that he would only do the deposition if I got approval from or coordinated with the two JAGs that I was trying to have sanctioned by or the two attorneys rather, that I was trying to have sanctioned by the court, who obviously were not going to.
I love that show too.
And so that's what I came to meet with him about. And I told the receptionist that he would make time for me. I offered to buy him lunch, and then hopefully over lunch
gonna
I
bribe
could show him
him,
the
huh?
paperwork that I didn't want to share with him electronically. And then we could go forward with the deposition, which was scheduled for that afternoon. And I had anticipated it would only take a couple hours. I just wanted to
Wow.
clarify some of the things
That's
that
devastatingly handsome,
he,
is what you're saying.
clarify on, legally on paper and under oath and everything. The things
This
that
guy's
he
in a
had,
lot of trouble.
said in a declaration that they had,
I
in
think
my
so,
opinion,
yeah.
coerced from him after his deposition. So I think if you saw all of the text messages, not just the ones he selected out, you would see that there was an ongoing conversation between the two of us. And I think the emails that I sent you also represent that. And I don't see an indication for this TPO. There was no alcohol, there was no intoxication, there was nothing threatening about my presence in a public building. I thought it was, and I don't know who told the police that I had a weapon, but they came at me very aggressively. Could have turned into something, pretty dangerous. They blocked my car in. I wasn't doing anything. I was trying to cancel the deposition and see if I could get my money back. when I was sitting in the car. So, and I don't know anything about this profuse sweating. The police officers, you know, I asked them to breathalyze me. They didn't want to do it. I asked them to check me or my car for weapons. They didn't want to do that. They didn't want to write a police report. I think they realized they've been had, and that was the end of that. So,
well, we appreciate you
know,
taking time too. That's
I
information we really
think that
needed.
This is a bit, Mr. Shadler, I understand he's scared, but I think that the fear is coming from the U.S. Attorney's Office and the JAG's office in Oregon, which have nothing to do with it. He's not in the military. They have no jurisdiction with this. This is a case that's in Washington State. You know, I've got the subpoena signed by the clerk now. I didn't have it on that day, and that's why I wanted to explain to him that in order for the subpoena to be completely official as a pro se, I have to have it signed by the clerk of the court.
You still want this guy to come in
that
as a
means
witness for
driving up
you,
to
though?
Tacoma, coming back and everything. So I wanted to see if he would just do the deposition, which was paid for. I'd give him the one that I had, and that I would, you know, assure him that I would go to Tacoma and get it signed off, so that if these attorneys gave him a hard time about testifying, he could say, look, I was under subpoena. I didn't have a choice. So I think, you know, I mean, I know we're only talking about this this restraining order, but I don't think there's any indication for it. Mr. Shadler has testified in the past that there was no history of violence. He testified to that during his deposition. He sent me an email congratulating me on getting an honorable discharge. He's the one that wanted to use his City of Vancouver email address, even though I told him I thought that was a bad idea. The multiple emails that he's referencing were exhibits, and they're PDFs, and I was only sending them 2 or 3 at a time, because I know that some servers you can't send very much through them.
Welcome to overtime, by the way.
I asked him if he had, when he was deposed, I sent him he got a bunch of exhibits. And these are lengthy exhibits, you know, they're from the whole military proceedings and stuff. So that's why they're in multiple emails like that. I had hard copies with me when I came over to his office, so you could go through those too. And I was hoping that would shorten the deposition time, so that I said, look, I'm just going to be asking about this, this, and this, and then we can get out of there. And so I don't know why he could have. Nobody told me to leave his office. They told me he wasn't there. Then they came back later and said he just wasn't going to be available. So I left. You know, it was obviously a disappointment, because I had paid for the deposition, and I had hoped to meet with him personally so that we could just go over the materials, and I could explain to him why these attorneys who have no jurisdiction in Washington State are calling him up or emailing him and telling them these things, that they have a motivation to have him not
to pay
talk.
Good chance.
Were you, so you have the subpoena signed, when you went to his workplace, were you trying to give him a copy of that, or forgive me if you mentioned this and I just missed it, but.
I was trying to show him what the issue was. I did have the copy that's in the exhibits you have there. I had that with me, and I was going to show him, look, if you'll accept this subpoena, I will go up, we'll get this deposition done, because, you know, you told me you had time today to do it. It's paid for, and I will go up to Tacoma and have the clerk sign it. I'd already talked to her on the phone, and she's like, yeah, just bring it up here, but it's a long trip. Maybe you would rather mail it up and then I can send it back. And I'm like, well, time is of the essence here. I'm trying to get this deposition done before this case in
Probably more like covering your car.
You know, this case gets going, or something changes with this case, and I lose the opportunity for discovery. That's what I wanted to meet with Mr. Shadler about, and to kind of explain the other side of the story, which doesn't really translate over an email or a text message, because he was only getting one side of it from Brian Leibel, who's a JAG in Oregon, and I'm not sure what the DC AUSA was telling him, but I'm pretty sure they've backed off, because I went to the court and asked them not to instruct them not to contact him. because this is a matter that's not in their circuit. It's in the Ninth Circuit here in, on the West Coast. So the AUSAs that were originally in the case in Washington State were excused or dismissed by the judge in the federal court up there, which I believe I gave you a copy of that order. And that's kind of the gist of it. I was just trying to work around what I thought would work for Mr. Shadler, and unfortunately,
The short
I'm up against
story.
The attorneys, the
Cliff notes
government
only.
attorneys who don't want him to tell the truth.
Did Mr. Shadler or anybody else tell you at some point not to contact him anymore?
No. I can show you text messages from the 16th in which he says, I mean, he could tell you, he could show them to you too, because he sent them. He says, like I said, I have no issues doing the depot. I don't know the law enough to know the requirements. So that's what I was doing, was bringing the law to him so he could see it.
Harvick.
And he doesn't say anywhere here, don't contact me, don't, go, he wants me to go through the JAG, but that's not that's not an
He's like
equitable thing for me. That's what I wanted to explain to him, was like, look, they're not going to talk to me. They're not going to work with me. I'm not in the military, neither are you. If you want to get an attorney to talk to me, I'm fine with that. I said, get an attorney. I'll talk to your attorney.
You're a member, but it's okay.
I'm going to subpoena you for this case. I need this
How
information.
dare you threaten to subpoena me?
And he says in here that he was called as a witness by the government. He actually wasn't. I called him as a witness by the government, and they produced him. He was my witness. You can't handle the truth. And that's why I filed the request for sanctions against those attorneys for tampering with the witness.
Witness tampering.
I feel that these
Judge,
attorneys
say
want
something or
this
he's gonna
in
keep
place
going.
so they can
Jesus.
use this as
Yeah.
a tool against me.
When he
I don't
takes
think
a
there's
breath, jump in.
Yeah.
I'm pretty sure Mr.
three
Shadler
times
knows
he
that there's
stopped.
this whole thing went down in 2014, 2015.
Oh God.
I went to his house after that. He loaned me a jacket for a hearing. He knows that, and I know he's a good guy, and I'm not. He's caught in the middle of something that I got caught up in, and all I want him to do is just be truthful about it. And I
All
think
he
he's
wants
just,
to do is leave me
he
alone.
doesn't know the process.
We just had
and
both of them live.
unfortunately,
We were
I've had to
circling
learn it.
back
I'm a
because we were
physician,
just
not a lawyer, and I didn't know the process either. And so, these guys, these government attorneys can be very intimidating. I mean, I had a small claims case here, and the U.S. attorney showed up, and I don't know if it was you. I don't think it was you, Your Honor, but the judge was like, he couldn't believe that the U.S. attorney's office was showing up in his court. They are impressive when you first encounter them. You think, wow, the DOJ is here. So I understand why Mr. Shadler would be intimidated. But on the other hand, my situation is pretty bad. I was an innocent person, and I got my life taken away from me. I didn't go to prison, but it was close.
Judge, for God's sakes, Judge, say something. Judge.
And then Mr. Shadler, anything else you wanted to follow up with?
Nope.
I would just add, he said I didn't notify him till last minute, but I have an email starting on the 10th where I said,
He
please
sent me an email during the
go through
proceedings,
the
Your
US
Honor.
attorneys or the JAG, and then there was a couple other follow-up emails. So the fact he still scheduled the deposition, even though I kept saying that's why it worried me, because I kept saying, please go through the JAG, please work through them. And I still scheduled it, even though I said not to. And that's why the concern and, the tone of the emails I received. So, and
think these two guys wear the
if I
same
do,
size
you probably
jacket?
know this, but if I do a voluntary deposition, I'm at risk and I'm not covered by the government, because this deals with something that happened during the government. So they need to be there, otherwise.
I also
someone will
see
be
Eric as
protected
somebody that
for,
would layer up, so he
lawsuits,
could have
things
some
like
jackets
could
that are,
happen
you know what I
later.
mean?
So that's the whole thing of my angst, trying to be forced to do a voluntary thing.
Your Honor, if I could just rebut that, I just want to mention that, as I said, the text messages on the 16th, which were the day before, he's still saying, I don't have a problem with doing this. He just kept saying he at that point, he wanted to qualify it that I should go through the Oregon JAG, which was, that's impossible. And it has nothing to do. The Oregon JAG does not practice in Oregon. He's not barred in Oregon. There's no way he's going to talk to me.
But was it your understanding at that point that he didn't want to hear from you about this?
No, my understanding, if he would be forthcoming and give you all the text messages, my understanding is that he didn't understand. He didn't understand how this would work. And so my thinking was, well, look, I'm going to go over there and show him, take him out to lunch, show him why the JAG is saying
Hold his
this,
hand,
why they're
brush his hair,
misleading
borrow his
him
jacket.
to believe
Send
that
him
this
flowers.
is something that has to go through their office. It doesn't. And I wanted to show him the subpoenas and show him how this whole thing works.
Show him your what?
Once again, the communication
Assure
process is
him
broken
that,
down.
because this whole thing started out, he said, I want to help you. He said, he congratulated me for getting an honorable discharge. It took me years to do that. And
Because you did something dishonorable. That
obviously he
happened.
was communicating with me. If he didn't want to do it from the beginning, he should have said, look, I don't want to deal with you. There's this past history or whatever. I don't want to help you. You need to just take whatever legal action you feel is appropriate. And I would have just said, okay, fine. I mean, that's the attitude I've gotten from Mr. Wadan. And I said, fine. And I've gone to court in the federal court system, and now Mr. Wadan has to go get a private attorney. It costs him money, and it's a big hassle for me, but I'm willing to go the 9 yards to get to the truth. And I'll do that with Mr. Shadler as well. But I thought
let's go
was
10.
gonna
That's
make
a
life
first
a little
down.
easier on me because he knows my financial situation. We have mutual friends. I'm very disappointed that he, pulled up at the last minute, and the 911 call that was over.
Should
over
be
the top.
happy he pulled out at the last minute.
That was a recommendation, just to clarify, from not only our JAG, but HR, because of what other people were seeing, not what I was seeing, because I wasn't there, but that was a recommendation from the city. So again, that was not me. That was their recommendation.
I think
And
the
again,
judge is ready to
I'll
rule.
just add, I gave plenty of notice that, and I kept reiterating, please go through the JAG. I mean, like
You
I
really
said, I
can't
was
skip
willing
ahead
to
if
do
you
a
want.
deposition, but you need to go through the JAG subpoena and the proper procedures.
Did you say go ahead and fast
And
forward?
I
Greg?
just kept
Yeah, no, go
reiterating
ahead.
that.
If you want
I
to, if you want to
hope
find
that
it,
would get
yeah.
the point that that's what.
Process cannot be done by a party to an
Oh,
action.
and
so
it just, all right, go back. Just a little
arguably,
bit.
Mr. Murphy does that sort of thing. That doesn't. In any case.
Again, we circle back to this because we had the last two live.
All right,
and
so
we missed the
basically what I have
beginning.
to consider, I'm sure you probably both read the statute, but the big thing is whether there's a course of conduct and whether that course of conduct serves any legitimate or lawful purpose. I mean, that's really what it all boils down to. And there's a number of factors there. Any current contact between the parties that was initiated by the respondent only, or was it initiated by both parties? The respondent has given, whether the respondent's given clear notice that all further contact with the petitioner is unwanted. The respondent's course of conduct appears to designed to alarm, annoy, or harass the petitioner, whether the respondent is acting pursuant to any statutory authority, but not limited to acts which are reasonably necessary to, and then it goes through a whole list of things. And there's some other stuff that I don't think really applies here about contacting the petitioner's family and that sort of thing. That doesn't
We
apply.
just
to
heard James go on for an hour.
It seems to me, I don't see that there was anything that would constitute harassment up to maybe March 16th or so. That seems to be somewhere between March 10th and March 16th is when things kind of came off the tracks.
Exactly.
But even then, I don't know that I can conclude by a preponderance of the evidence that that these communications from Mr. Murphy do not serve any legitimate or lawful purpose. I will say that under the federal rules of civil procedure, service of a subpoena or virtually any other process cannot be done by a party to an action. So, I mean, arguably, Mr. Murphy doesn't have a legitimate or lawful purpose in serving any documents because the civil rules require a third party to do it. But I don't know if he knew that. And I think that at some point so the email from March 16th and the follow-up and going to Mr. Shadler's office and the follow-up messages after being swatted, I put that in quotes because the police were called. And it didn't turn out that way, fortunately. But up until that, I think everything was for a lawful purpose. That being said, even at that point, I just can't find by preponderance of the evidence that Mr. Murphy is harassing Mr. Shadler. And the big reason is Mr. Shadler basically told Mr. Murphy, you should go through the attorney about this, but I don't see anywhere where he says, stop contacting me.
And he also said he never told him that.
It's not required, but it's certainly important, especially because that's one of the first things the statute lays out that the court should consider when you're considering whether a course of conduct or whether contact serves any legitimate purpose. So I'm on the fence about it, honestly, but when that happens, generally the court has to deny the petition because it's up to the petitioner to prove the case by preponderance of the evidence. I'm not unconcerned that Mr. Murphy's showing up at Mr. Shadler's place of business. But I'm not going to get into whether his legal action has merit or not, because I don't know. And also it's irrelevant. So with that being said, Mr. Shadler, you do have the right to appeal my decision.
Well,
But
that's pretty
Mr.
much it then.
I'll just tell you, and so it's all on the record, I would advise you not to have any further contact with Mr. Shadler unless it's through a third party
All right, Creed. Well, that's pretty much it for that case. I was surprised. I thought he was actually going to grant him the harassment, but
I was thinking at least a little something, but
nothing
after all that. Yeah, interesting. All right, they all can't be winners, right?
No, they all can't, but that's all right. We had some great things today. I hope everybody had a lot of fun. We'll be back for We Gotta Chase Friday edition. So make sure you're there for that. Like this video, subscribe, yada, yada, yada. Until next time, Create anything else?
Nope. Just don't forget 2 members only at 6 o'clock. Going to be a fun one tonight. So we'll see you at 4 or 5.
She's a doozy. Until next time, please remember.
Bye.